Daniel, just wanted to let you know that YouTube is on.
You guys hear us?
Yes, we can. Thank you. Attorney Ferry, would you say hello, please? He's muted. So unmute yourself, please.
Sorry about that. Excuse me. Yes, good morning. Hello. Glad to be back today.
Hope your travels went well.
Well, they did go well, and got my work done, and I'm back in Massachusetts, so glad to be here.
Okay. Mr. Reich, would you say hello, please?
Hello. How are you? Thank
Great.
you.
Okay, and Mr. Pucci, if you could say hello.
Hello.
And Mr. Broderick, well, let's just make sure everyone can be heard. Mr. Broderick, would you say hello?
Morning, everyone.
Morning. Michelle Bertrand, would you say hello?
Good morning, everyone.
Good morning. And the Corys, if you could say hello, please.
Yes, good morning.
Good morning. Are the Salpes present today? It's 10 o'clock. Are there any, I mean, we're not on the record yet, but are there any preliminary matters that anyone needs to discuss before we begin
I did.
examination?
I did. It was a scheduling request. It didn't really pertain to today. It can wait
Okay.
or whatever you prefer.
Sure. And are there any other matters that need to be discussed? Mr. Pucci, go ahead and tell us what that scheduling matter is.
I appreciate that. And good morning again. This is George Pucci from KP Law. I represent the town of Oakham. The Friday hearing session, and I know there are a lot of schedules involved in this, so you may not be able to accommodate me, which I totally understand if you can't. Friday is, I have been a volunteer judge in the Mass Bar Association mock trial program for high school students for the last like 5 or 6 years. And every year I go to the final that is held in the old, in Faneuil Hall in the old State House, whatever they call it. They're a big event for the final, you know, for the state championship, and then they go out of state. That the final is scheduled for Friday. I'm not a judge. I purely go, you know, as a supporter and a participant in the program. And also they use real judges on the final. So I get to learn, you know, how to do a better job the following year. That is Friday, and I can miss it if you can't accommodate me. But I was seeking, you know, to explore whether we could talk about a potential other day other than Friday for the trial session that we had scheduled for Friday. And again, purely as a, you know, personal accommodation, it certainly isn't anything that, you know, affects my ability to handle this case or anything like that. It's purely a professional request. Because like I say, I participate closely in that program. I was a judge twice this year, in addition to the regional finals that they had at Clark University. And as I said, I go every year to this final event. And I'd prefer not to miss it if possible, if we could accommodate maybe thinking about a different day to have that. I think it was anticipated really the final hearing session for this case for this coming Friday.
All right. Thank you, Mr. Pucci. Thank you for alerting us to that. And I expect we will revisit that request at the end of today.
Thank you.
When we have more information. Mr. Ferry, we had discussed that the non-town interveners would begin the questioning today, the further cross-examination of the noise expert, of the company's noise expert. Would you please begin that cross-examination, Mr. Ferry, and we will go on the record.
Okay, thank you very much. I think Mr. Pucci mentioned that he might like to go first, and assuming that he doesn't take the whole day, I think I could follow Mr. Pucci if he would like to begin.
That would be fine. Mr. Pucci, would you like to do that?
Right. I did speak to Attorney Reich on the way in this morning, and I did speak to him about that I did intend to go first today. I don't know how long it will take, and if we can accommodate Attorney Ferry when I conclude. But we could get started and see where we're at. I mean, I have a pretty thorough cross-examination prepared, so it's not going to be 45 minutes or something like that.
No, that's fine. I mean, if Mr. Reich and Mr. Ferry are okay with your proceeding, Mr. Pucci, go ahead.
Great. And are we on the record now?
Yes.
Good morning. Is Mr. Callahan present on the witness panel?
He is.
Okay. Good morning, Mr. Callahan. My cross-examination questions are this morning are directed to you specifically as the preparer of the report from Epsilon dated January 13, 2026, which is EFSB-OAK-38 (1) close paren in the evidence in this case. So my questions are going to be directed to you unless I indicate otherwise. My first question, sir, is who hired you to do your noise analysis in this case?
Rhineland, the project company.
And when was that? When were you initially engaged?
Just give me one moment to find that date. June 21st, 2023.
And have you continuously been engaged in the matter from 2023 until now?
Yes.
Has the scope of your engagement changed in any way since the time of the initial engagement and up until the time we're sitting here today?
No.
And are you appearing as an expert witness for Rhineland or Moraga in this matter?
I'm appearing for Rhineland. Moraga Energy Storage is the name of the project that the study was conducted for.
Are you being paid for your work as a consultant in this case?
Yes.
And who is paying for your work?
Rhineland.
Okay. And I asked if the scope of your engagement had changed, and you said no. So what was the initial scope of your engagement by Rhineland?
To conduct a sound level assessment for the project, including an ambient sound level measurement program, acoustic modeling, and developing the report that you referred to earlier.
How much are you being paid for your work as an expert witness for Rhineland in this matter?
Objection.
Sustain.
Will you have a role in this project after the evidentiary hearing has concluded?
If we are engaged from Rhineland further to do further studies, then yes, we would be. But as it currently stands, I don't believe there's a further role at the moment.
Okay. What percentage of your consulting work is done for project developers versus proposed host communities for energy projects?
I don't have a specific breakdown, but the majority of our work is for the developers of projects.
In looking at your CV, it looks like 100% of your work is for developers and none for a potential host community. Is that correct?
Everything on my resume is for developers, correct?
Have you ever testified against a proposed energy project?
I have not.
Do you agree that battery energy storage systems are and have been deployed and operated in both indoor facilities and outdoor open air facilities?
That is my understanding, yes.
For comparable large-scale configuration BESS equipment, comparable to the equipment proposed in this case, is outdoor noise propagation from a BESS more easily controlled by the choice of situating it in an indoor facility or an outdoor facility?
That depends on the site layout and the specifics. It's a project-specific answer to that question.
And how so? Can you describe that a little bit for me?
Well, if there's a project within a building, that building still has cooling requirements, and therefore there is still external cooling equipment that needs to be located, and that can produce different sound levels. So it's not necessarily easily stated one way or the other if indoor versus outdoor is better for noise considerations.
How about for this project, would indoor or outdoor be better for potential noise propagation?
I wouldn't be able to say. We only analyzed the proposed project, which is a containerized design.
Do you agree that the project that's the subject of these proceedings is proposed in a quiet rural residential area?
It's definitely a quiet rural area, yes.
Is this an ideal location from a noise pollution compliance standpoint for a facility of this scope and scale, in your opinion?
Our study shows that it will comply with the state requirements, and therefore it is acceptable from a noise perspective.
It's acceptable, but is it ideal?
That's not really for me to say. I don't have a definition of ideal. I've just analyzed the project with respect to the noise limits and present whether it will meet those or not.
When you were first consulted in the site selection process, but prior to the company's final site selection, did you offer an opinion relative to the noise compliance feasibility for the Oakham site?
No.
Did you offer an opinion relative to the noise compliance feasibility for the outside facility design prior to the creation of the plans by the company's engineering consultant?
No.
In the company's response, and this I don't need you to pull up unless you need to, because I'm just going to quote from it. The company's response to IR EFSB NO7, the company stated, quote, "The project is not anticipated to affect wildlife species," close quote. And then it says, "Affected individuals, paren wildlife, close paren, would be expected to return once the project is operational." Is that your understanding?
This is Mark Bergeron. Mr. Pucci, if I could, I'm the wildlife and wetlands subject matter expert on this, and I helped with the submission of this. I actually prepared this with Mr. Callahan. So can you just repeat your question? I'd be happy to answer it.
Yeah, I can repeat the question. My question is more for noise issues. So let me ask a different question before I repeat it, and I'm happy to have you answer it too. But it's really what I'm getting at is noise in relation to wildlife. So that's the purpose of these few questions that I have on the issue. So in the IR response NO7, the company stated, and I'm quoting in part, "The project is not anticipated to affect wildlife species. Affected individuals, wildlife, would be expected to return once the project is operational." Is that consistent with your memory of those IR responses?
Yes, that is, and I mean, there aren't any standards in the Mass DEP noise policy associated with wildlife. And so then we would have to defer with regards to wildlife to any other standards that are in any other regulatory programs. And there currently aren't any in the Commonwealth of Massachusetts or the federal. And so, this response is based upon, our experience working on large development projects, whether it be a battery storage, a warehousing facility, residential. Typically what you'll see is displacement of species, and then species will return to use whatever habitat is remaining on and around the project site, and essentially adapt to some of the noise going on around them.
And specific to the noise expert, Mr. Callahan, is potential effect of noise propagation on wildlife specifically within the scope of your professional responsibilities when you do a noise study?
No, our analysis typically focuses on the impacts to humans.
Okay. Question for either of you. In terms of wildlife, is it true that wildlife can perceive and depend heavily on sound perception for survival?
When you use the term wildlife, I mean, obviously there's thousands of different types of species. They're all affected differently, different portions of their life cycles. And so that's a very general question. If you're, I guess if you're asking along the lines of can noise affect certain portions of species life cycles? Yes, studies have shown that it can.
And another question on that is it true also that certain species also happen to have hearing sensitivity in sound frequency spectra that exceeds...
I'm sorry, that have hearing sensitivity what?
In sound frequency spectra that exceeds human hearing?
In a general sense, my understanding of different types of wildlife species, whether they be mammals, amphibians, reptiles, in some instances, yes. I mean, just a common example that we all understand is dogs' ability to hear different frequencies than humans.
And I will ask you, because you pointed out, you can't answer these questions kind of generally. So I'll ask you about the project site specifically. Are you aware that the following, in terms of mammal species, are you aware that the following have been seen in this area? And that includes white-tailed deer, black bear, moose, red fox, coyote, woodchuck, skunk, as well as brown bats. Are you aware of those being seen in the vicinity of this project area?
Yes, sir, I am.
And in terms of bird families or species in the area, are you aware that owls, woodpeckers, crows, warblers, and jays frequent this area?
Yes, these are all species common to Massachusetts.
And in terms of amphibian species, do you agree that wood frogs, American toad, spotted salamander, and newts are in the area of the project site?
Yes, again, all commonly found throughout Massachusetts.
And then in terms of reptile species, the area has included box turtles, as well as garter and grass snakes.
I'm not from the area. Hasn't been mapped for box turtle. That's a state listed species, so I don't believe that's present within the area based upon the fact there isn't any mapped habitat, state listed habitat in the area. And I would expect that this area on the portions of the project site and surrounding areas.
I'm sorry, that this area, what?
Portions of the project site and surrounding areas are capable of supporting those types of species.
So other than box turtle, as you sit here today, is it still the opinion of you on behalf of the company that all of the species that we just identified that you agree are in this area would return to this area after the introduction of additional noise spectra as a result of operation of the project?
Well, you just asked me general questions about could they exist in the area. We actually haven't established the fact that they have. And I'll point you back to, the state regulatory standards and the state regulations are all based in science and scientific literature, and they're developed in accordance with different universities and other stakeholder groups. And they do consider science, and they contain performance standards that require and consider science as well. So again, the project is going to be constructed such that it will be in compliance with all applicable state regulatory standards, none of which require or prescribe an analysis of noise on individual wildlife species.
I'm not asking for what the state says. I'm asking for what you say and what you said in the company's responses to the IR requests. As you're sitting here today, all of the species that we just listed, which you just agreed are in this project vicinity, is it still your position that all of these species will return to that project site in the immediate vicinity, despite the fact that you're going to introduce new noise propagation sources as a result of operations of the project?
Yeah, my professional opinion is that this project, the way it's been designed, and the areas that it's going to impact on site, will not have an overall adverse effect on any wildlife populations in the area to exist in and around this area.
And can you cite for me any professional reporting that I would be able to access to support that opinion?
Again, it hasn't been introduced in the proceedings. We did an analysis on the regulatory standards, and you're asking me general questions about wildlife, not particularly on this site. Yes, you asked me, do I agree that those species could utilize areas on the site? Sure, but are they there? We don't know.
No, I'm asking you, do you have any scholarly publications that support your claim that all of the species that we just talked about will be able to return to the immediate vicinity of this project despite the introduction of new noise propagation source as a result of the operation of the project?
None have been submitted by us on the record, no.
How about as you sit here today, can you cite anything for me that I might be able to Google or get ChatGPT that I can read for myself to support that claim?
Not unless you allow me to open my computer and start to do a search.
No, I think we can. So you think that there are scholarly publications that support your opinion that wildlife species will return to the site despite the introduction of new noise propagation as a result of the operation of the project?
Yes, I believe you could find scientific papers that analyze development versus general wildlife use of area over time. That would show, again, some species may be more adversely affected than others, but yes, there are papers that I'm sure that there are papers that exist on this topic.
Yeah, I would request, Mr. Presiding Officer, that we do a record request for that, which would be for scholarly publications which support the claim that wildlife species will return to the project area after operations begin.
That's fine. So we're going to call that RR-OAK-3.
Thank you.
I'm just wondering how that's relevant to 40A Section 3 hearing.
Do you want to respond, Mr. Pucci?
Not really. I think from now on, because I'm trying to be a little more polite in the proceedings, so I'm going to just let objections go to you, Mr. Presiding Officer. If you want me to give my position on something, I will. But sometimes it becomes heated when council starts having a dialogue, while you sit there and until it blows up sufficiently. So whatever your preference is, but I'm going to try to err on the side of not having a knee-jerk reaction to Attorney Kaplan's statements during the proceeding, unless you ask me for my opinion.
Yeah, I probably won't go into the reason, but I do see it as relevant, Mr. Kaplan, and I'll just leave it at that.
Thank you. Now, I think these are questions for Mr. Callahan only. As of today, is the company's selection of battery unit equipment for this proposed facility in Oakham, in fact, the Tesla Megapack 2 XL?
Yes, it's the Tesla Megapack 2 XL FN03.
To your knowledge, do Tesla Megapack 2 XL units have integrated thermal management systems?
Yes.
And do the thermal management systems include the use of fans to circulate air throughout the enclosure of the battery unit?
Yes.
Do these fans produce noise that is audible to humans from various positions they may be situated outside the battery enclosure?
Yes.
Please describe the general characteristics of this fan noise propagation in terms of bandwidth, directionality, and A-weighted sound pressure levels for a single Tesla battery enclosure unit.
Sure. So that what you just described is exactly what our study models and evaluates. So the fans of the Megapack are located on the top of the unit. So when the fans cycle on, they produce sound just like any other fan. And those sound levels are propagated in a spherical direction. So basically in all directions from the sound source. And that's how it's represented in our study.
Thank you. And fan noise propagation is mid to high broadband frequencies, and depending on fan speed can range from 82 decibels to over 100 decibels per unit, correct?
The numbers you just cited would need additional criteria to be valid. For this particular project, there is a fan throttle in place that will cap essentially how fast the fans can spin. And that in turn limits the amount of sound that can be produced by the units.
I'm going to get into a little detail about that later, but as a general proposition, does that sound like a reasonable range to you, 82 to 100 decibels?
No, because the 82 value is the highest value, and that is a sound power level. So that isn't the sound pressure that would be experienced if you were to stand next to the unit. That's a metric that is used to plug into our acoustic model, and 82 would be equivalent to the highest value. So there is nothing that's 100 decibels.
Okay. Do Tesla Megapack 2 XL units also include powered electronics such as inverters and DC converters?
Yes, that is my understanding.
And do the units also include coolant pumps and compressors for circulating coolant fluid throughout the battery enclosure?
I believe so.
And do these additional powered internal components qualify as noise sources?
Yes, they would be included in the total sound emitted by the unit.
That was my next question. That they would they produce sort of a sound from the battery enclosure itself, right? Like a casing noise. Is that familiar with that term?
Sure. The sound levels that we're representing include all of those sources. So when the manufacturer does their testing on the units, they measure it operating with all of that operating simultaneously, and therefore the sound levels that we plug into our model are inclusive of all those sound sources.
So to sum up, your model included both casing noise as well as fan noise, which are two different things, right? Or is that wrong?
Yeah, that's more applicable usually to something like an emergency generator where you have an engine or something that produces a significant amount of sound. But to your point, there's more than just the fans that are producing sound, and that has been accounted for.
Do you agree that the Mass DEP noise policy, and that's attached as an attachment to your report, which is Exhibit Oak 38. Do you agree that the Mass noise policy regulates both broadband sound levels as well as, quote, pure tone, close quote, noise conditions?
Yes, that's correct.
Those are two totally different things, right? They're both related to noise, but they're separate issues, correct?
Yes.
In other words, if you violate for broadband sound levels, well, let's say it the opposite way. Even if you don't violate applicable broadband sound levels, you could be in not you personally, but one could be in violation of the pure tone requirements, right? In other words, it's not all or nothing.
That's right. Both of them are requirements.
Is it true that increased propagation of tonal noise, particularly low frequency tonal noise, is difficult to mitigate by means other than altering the equipment itself?
In general, lower frequency sounds are more difficult to mitigate due to their longer wavelengths. Yes.
Now I wanted to, I am going to ask if the board can put this up at one point, because I want to refer to specific figures. First, a couple of general questions, Mr. Callahan. On the issue of ambient noise data, Epsilon conducted both long-term and short-term baseline ambient sound level measurements at a total of 5 specific locations, correct?
Yes, that's correct.
And that was to determine through modeling what the sound impact might be at sensitive receptor sites in the vicinity of the proposed facility, correct?
The ambient monitoring was done to determine the existing sound levels in the project area. The modeling is then done separately to predict how loud the project could be, and then those two values are compared to determine compliance with the Mass DEP noise policy.
You anticipated one of my later questions is long-term and short-term baseline ambient sound level measurements. Those are things that, actual data that you collect in the field, correct?
Yes, that's correct.
And then when you determine through modeling what the expected sound levels are in certain receptor areas, that is not data collected in the field. That includes the data that you collected in the field, and then it includes information that you input into a computer system at your desk, correct?
Yes.
And I do want to, it would be useful, this is to the presiding officer. I have quite a few questions related to the report specifically. In the old days, we'd all have a copy of the exhibit in front of us and we'd be in the room in person together. I think the easiest way of doing this would be if we could put it on the screen.
We can do that. If you just direct us which portion of the report you would like on the screen.
I appreciate that. Let me just get my copy. Okay. So the Exhibit 38 is, I would like you to look at figure 5.1 on the report. That's on page 13.
I'm sorry, is that 5-1, 5.1?
5-1 on page 13. I can't tell if that's up or not. I'm looking at my hard copy.
So it is up, and just to be clear, it's Oak-38, open parenthesis 1.
Right. I may refer to it a lot, so if I say Exhibit 38, I'm referring to Oak-38, paren 1.
Great, that's fine.
And just to back up a little to orient ourselves, Mr. Callahan, I asked you that you conducted long-term and short-term baseline ambient sound level measurements at 5 specific locations. Do you recall that?
Yes.
And then before we look at them specifically, that was to determine later through the modeling what sound impact might be at sensitive receptor sites in the vicinity of the proposed facility, correct?
Yes.
And those locations are reflected on figure 5-1?
That's correct.
Is the establishment of existing baseline ambient noise levels in a particular location an important first step in conducting a sound level assessment for determining the potential impact of a prospective new noise contributor in a local vicinity?
Yes.
It seems somewhat common sense, but we have you as an expert here today, so can you just explain to us why?
Sure. So with respect to the Mass DEP noise policy, that policy is tied to the existing sound levels. So in order to determine if a project will comply with the requirements of the Mass DEP noise policy, the first step is to establish how loud or quiet a particular area is. And that is the purpose of an ambient sound level measurement program. And these locations that we're looking at on the screen represent the areas where we placed microphones to do those measurements.
Thank you. I'm going to ask you about those. Looking at figure 5-1, you have LT1, and for the stenographer, that's capital L, capital T1, no period or anything between them. The same for the rest of these letters I'm going to read. So on figure 5-1, you have LT1, LT2, ST1, ST2, and ST3 depicted on the figure, correct?
Yes.
And the LT and the ST, that refers to long-term or short-term monitor devices in the monitoring location, correct?
Correct.
And again, you use those to establish baseline ambient sound levels so that you can then compare to the 10 decibels over ambient compliance standard in the Mass DEP noise policy, correct?
Yes, that's correct.
And that's on the broadband sound component of the DEP noise policy, correct?
Yes.
It doesn't relate to pure tone measurements, correct?
I'm
sorry. Let me rephrase that. That was not a good question. The 10 decibels over ambient, that refers to the broadband maximum under the policy. It doesn't relate to the pure tone requirements. Is that fair? The 10 decibels over ambient.
Right. There's a 10 decibel over ambient broadband requirement, and then separately there is a pure tone requirement that involves individual octave bands or different frequencies.
Great. Now, how do you determine whether to employ a long-term or short-term monitoring location when collecting the data for establishing baseline ambient sound levels in various locations?
So with respect to the Mass DEP noise policy, we always do long-term monitoring because that gives us the best picture of what the sound levels do over a 1-week period. That is the period that the Mass DEP favors. And then we also do additional monitoring on a short-term basis at additional locations where we may not have permission to leave equipment for a long period of time.
Yeah, that was my next question. How long are these periods? First, long term, and then the short term.
So the long term, we always do a minimum of 1 week. For this particular project, the meters were out there for 8 days. And the short term locations, those are attended measurements. So those are visited by a field technician. The microphone is at those locations for 20 minutes during both a daytime and a nighttime period.
And I also asked, I don't think you answered it because I may not have been clear, is how do you make the decision whether to place a long-term monitor versus a short-term monitor in a particular location?
Well, the long-term monitors are always placed onto parcels where we have permission to leave equipment unattended. And the short-term locations use public rights of way or areas where we can access for brief periods that don't involve going on private property.
Okay. Looking at the short-term and long-term monitoring locations on figure 5.1, you have 2 long-term monitoring locations. One of those is LT1, which is on the access road to the project site in the vicinity of Coldbrook Road. Do you see that on the screen?
Yes.
And then you have another LT2 on the southern border of the project site, correct?
Yes.
And when you say, that consideration of whether to place a long-term or a short-term monitoring location depends on your ability to access the property. You had access on your property line for any of these residential lots immediately abutting the west side of the project, correct?
Yes.
Counting 4, actually another one at the bottom, 1, 2, 3, 4, 5. You could have put long-term monitoring locations on your side of the property at any of those boundaries, correct?
We could have, yes.
And why did you pick the 2 locations that you did pick for long-term monitoring locations?
So for LT1, that was representative of the closest residences to the west, at a similar setback from Coldbrook Road as the homes are. And then for LT2, we wanted a meter that was essentially set back far from any roadway to be representative of a true quietest area that we could possibly get to.
Okay. Just in terms of private property lots, we've got the one I just identified on the southwest corner of the yellow parcel boundary, then 1, 2, 3, 4 lots above that parcel on the immediately abutting the west side of the project site. And then above that along Coldbrook Road, there's also a, can you see that box? That's another private property lot, correct? A little bit further up on Coldbrook Road?
Yes.
Okay. Now, in terms of what you just said about placement and location of the homes being near Coldbrook Road, in terms of testing noise compliance for a residential property, that includes the entirety of the property, correct? Not just where a residence is particularly located.
Our study has evaluated compliance at all of the inhabited residential parcels, including the inhabited residential parcel property lines.
You're not testifying that you can violate the noise policy for broadband sound level 10 over ambient at certain portions of a residential property lot, are you?
Not at an inhabited residential lot line.
Well, how about, right, an inhabited residential lot line? That means that it encompasses the entire lot, not just the inhabited residence, correct?
Sure.
Yeah, so I mean, let's look at a specific example. Just take the 4 private property lots immediately abutting the west side. Despite the west side of the project site, despite the location of the actual residences, you have to comply with the policy for any portion of those lots, right? Not just a specific area that the residence is located.
Yes, that's how our study has shown compliance.
Now, LT1 is quite a bit closer to the roadway, Cold Brook Road, than the let me strike that. First, on these, on the 4 lots immediately abutting the west side of the project site, why did you not use the vicinity of your property boundary with those lot lines to place a long-term monitoring device?
Well, in an area like this, there isn't a lot of variation from one location to another. So we had one location that was more representative of what those homes are experiencing, and then a second location tucked further away. I think there was only a 1 decibel difference between LT1 and LT2, just for some context. So the way that we're representing ambient is essentially the same, regardless of which location we chose to use.
Well, LT1 is quite a bit closer to the roadway, Cold Brook Road, than the other locations that I just identified to you, correct? In other words, the very far east side of the private property lot lines, and then your farthest west side property boundary. That's a lot farther away from Cold Brook Road, right?
LT2 is further away from Cold Brook Road than LT1. Is that
No, I'm asking about, I'm just using as a specific instance, the 4 private lots immediately abutting the west side of the project site. If you put the long-term monitoring locations on along your property boundary, but on the very west side of your property boundary, not including the roadway, the access roadway, and then the very easternmost side of the private property lots, those locations would be a lot farther away from Cold Brook Road, right?
They would be further away from Cold Brook Road, yes. But
and what yeah.
But the L90.
I'm sorry, I didn't hear you. You were interrupted. But what?
But the L90, the metric that we're interested in measuring, is not really influenced by a sparsely traveled road such as Cold Brook Road.
Well, it's sorry for interrupting, but it's a long-term monitoring location, so it's a week, right?
It was 8 days for this project, yes.
8 days. So it's obviously going to pick up more traffic noise, no matter how sparsely traveled Cold Brook Road is, than the very eastern most side of any of those 4 residential property lots, right?
It would, but again, the L90 metric essentially filters out occasional roadway traffic. So unless the traffic on that road was continuous for an entire hour, the L90 is going to exclude sound that is sporadic like that.
Despite your answers on that, as we're sitting here today, do you think it would have been a good idea to put a long-term monitoring location at any of the easternmost property boundaries of any of these 4 residential lots, instead of where you put it close to Cold Brook Road? And again, on your side of the property boundary. Don't you think that would have been a good idea?
I think the way we have documented the sound is representative and conservative with respect to the sound levels at the homes and at those property lines.
You keep saying the homes, but the policy pertains to the entirety of the lot, right?
It does. However, the Mass DEP focuses on the areas around inhabited residential properties or other inhabited structures. So their focus is on the buildings where people reside and the spaces immediately around those buildings.
And that isn't stated anywhere in the policy, right? Policy covers the entire lot, correct?
It has been stated in interpretations issued by the Mass DEP.
Is that in the interpretation attached to your report?
Yes,
That and just to be clear, are you saying that the interpretation says that you don't have to comply with regard to the entirety of the lot?
I'm saying where the focus of the Mass DEP is, if they were to respond and take a sound level measurement, where that measurement would occur is near or at an inhabited structure where noise sensitive receptors are. That's what the interpretation states.
Now, referring back to your figure 5-1, look at the location of ST1. That's located down on the southwest part of the figure. That's along Coldbrook Road at the roadway entrance to the Oakham Elementary School, correct?
That's correct.
And again, that short-term monitoring location is in the immediate vicinity of the traveled way along Coldbrook Road, right?
Yes.
Why did you not place the monitoring location in the actual area of the school itself if you wanted to get a true sense of ambient noise levels where the school is actually located?
Again, it's just a spot measurement that helps inform what the ambient levels are in the area. For purposes of compliance, we did not even use the value measured at the short-term locations. We used the lowest values measured at the long-term locations.
The school is actually depicted on figure 1, right? It's further southwest of the ST1 location.
Yes.
In the aerial, it looks like it's a white building that you can clearly see at the end of the roadway there.
Correct.
And I'll ask, and first of all, you're aware that the elementary school has an actual sightline vantage point to the project site, correct?
I couldn't say for sure. I'm not aware of all the sight lines.
Are you aware that the school is up gradient at least 60 feet from the area of the project site? An elevated location, an elevated topographical location, at least 60 feet higher than the project site.
I don't know the exact value, but the acoustic modeling that was performed does include topography and terrain for the site and all surrounding areas. So the elevation differences are accounted for in the model.
Then I'm asking you, are you aware that this is at least 60 feet at an elevated location from the project site?
I'd have to look at the specific value. I know it's elevated, but I don't know that it's 60 feet off the top of my head.
I was going to ask you later. In fact, there's no topographical information contained in any of the figures that you have in your report, correct?
That's correct.
And this issue of line of sight, that's a relevant determination when you're talking about the travel of sound, correct?
Terrain plays a role in how sound propagates, so it's all relevant, yes.
Then please look at ST2, which is depicted on figure 5-1. That's at the intersection of Coldbrook Road and Old Turnpike Road, correct?
Right, we're not seeing it on the screen currently because it's further to the north, I believe. So if you could scroll up.
Yeah, could you scroll up, Mr. Controller of the screen? Can you tell us when it shows up, Mr. Callahan?
Yep, it's there.
And actually, Old Turnpike Road is an even busier road than Coldbrook Road, right?
I'm not certain of that.
Are you certain that it's a traveled way, at least?
I believe so.
So that location of ST1 or ST2 that we actually had to scroll up to see it, that's farther away from the project site than at least 5 depicted residential lots, and is also subject to noise from the intersection of 2 traveled roadways. Why would you select that location for any type of monitoring?
It's just to give us a more complete picture of what the existing ambient sound levels in all directions from the project area are. For that particular location, again, we did not utilize that data with respect to compliance. It was just more information to show that we had gone further than just right on our own site.
And when you wanted to go sort of above and beyond, like you're describing, it wouldn't have been within the same sort of methodology to put some more monitoring in the area of the residential lot lines that immediately abut the project site? Would that have been useful?
Again, where we've placed the monitors were representative of those residential lot lines.
Okay. Please look at, I don't know if we have to scroll to see it, but please look at ST3 depicted on figure 5-1. Do we see that on the screen?
Yes.
And that's to the east of the project site. And just using figure 5-1 as reference, that's to the east of the project site, farther east than several residential lots situated between it and the project site, farther east from Forest Hill Drive, which winds up into a cul-de-sac from another main road, North Brookfield Road, correct?
Yes.
And why would you select that location when there are known residential lots and thus sensitive receptors which are closer to the project site itself? Now I'm referring to those specifically that are shown on figure 5-1 in that area of Forest Hill Drive.
Sure, it's the same answer that I provided. It's just additional data for all of those residential lots to the east along Forest Hill Drive. We have utilized the data from LT2, which is 1,000 feet from any active roadway. So we've essentially utilized the most conservative value that we have to represent all of those homes, even though those homes are likely producing some sound from their HVAC systems themselves. We've used the conservative value of the meter in the woods there at LT2.
I'm talking about I'm comparing it to ST3. Why would you use that selection when you know that there are residential lots that are closer to the project site, right? Easily seen on the vicinity of Forest Hill Drive.
Again, it's the same answer. It's just another data point. We already have values of meters at the lot line on our project site. And this is just more information to document what the sound levels are in different directions from the site.
Well, those residential lots in the area of Forest Hill Drive, those are also elevated above the project site and have a line of sight to the battery units, correct? Direct line of sight to the battery units themselves.
Again, I don't know the specific line of sight, but the elevation is accounted for in the acoustic modeling.
And do you recall that those residences are located 110 to 130 feet above the ground level of the facility?
I don't have the specific values, but I know that they are elevated.
Do you think that's wrong? If I were to tell you that they're 110 to 130 feet up gradient from the facility itself, would you tell me I'm wrong?
I would have to look at the specific elevation in our model.
And again, if you're going above and beyond to try to provide relevant data that's then going to be included in your modeling, wouldn't it have been useful to include monitoring locations in any of these areas that we've just talked about? Line of sight to the facility, 110 to 130 feet up gradient to the facility, and that include clear sensitive receptors, which are residential properties covered by the mass noise policy. Don't you think that that would have been useful to have monitoring devices in those locations?
Again, it's the same answer I've given. We have locations that are representative of those lot lines, and we're using extremely low values that are quite conservative at all those locations you're mentioning.
Okay. Now please move to, and by the way, you also didn't include any ambient noise modeling for downtown Oakham itself, correct?
I don't know what ambient noise modeling refers to.
Ambient.
I'm sorry, could I have just 1 second, please?
Sure. Yes.
Just a minute, thank you. Apologies, thank you.
No problem.
I'm referring to background ambient noise monitoring. I'm sorry if I misspoke. Did you do any ambient baseline data collection through short or long-term monitoring in any areas involving the Oakham downtown?
The only monitoring that we conducted are depicted on this figure here at those 5 locations.
Downtown Oakham has a church, town hall, and several residences. And it's if it was depicted on the aerial on 5-1, it would be slightly southwest of the Oakham Elementary School, correct?
I'm not aware specifically of where those locations are you're referring to, because it's further away from our study area.
So that wasn't a consideration at all, that there were sensitive receptors in Oakham Town Center, which is about 3,000 or 4,000 feet away from the project site itself, right?
Well, we're evaluating compliance at distances much shorter than those. So by meeting it there, it would easily meet it at distances that are 3 or 4 times those distances.
Well, okay, we'll leave that for now. Look at figure 6-1, which starts on page 20 of your report. We could turn to that. Mr. Callahan, just let me know when we get there.
Yes, we're there.
Okay, great. Please look at figure 6-1. This depicts sound modeling receptors, correct?
That's correct.
All right. And please describe what those are.
So those are specific points that we put into the acoustic model where we predict sound levels at those specific locations.
Okay. I'm going to raise my hand because this is both a long and maybe a somewhat adversarial question. But returning to my what I asked you earlier about whether it makes sense to have located the long and short-term modeling locations where you did. And just wait for the end of my question, please. If you were trying to determine in good faith whether modeled sound propagation from the battery units would exceed 10 decibels over ambient sound levels, wouldn't it have made more sense to place long or short-term monitoring locations at any of the actual sensitive noise receptor locations, such as R1, R2, R3, R4, R5, R6, R10, R11, or PL 1, 2, 3, 4, 5, 6, 8, 9, or 10, as depicted on figure 6-1.
So again, the monitors that we deployed are representative of these locations, as I've said.
So to summarize, you did not employ even one single short or long-term monitoring location at any of the 17 sensitive noise receptors identified in figure 6-2, correct?
Well, there was one closest to the PL South, but
I'm sorry, there was one closest, what?
our long-term monitor was close to the PL South receptor shown here.
PL South is not included in the 17 I asked you about. I'm going to get to PL South. I'm going to ask you about that, why you consider that not applicable. But I'm talking about the sensitive noise receptors, which are 17 of them. And I'm not going to belabor the point and reread the numbers that they are, but there's 17 located on here. And I'm just asking you to summarize. You did not place a short or long-term monitoring location at any of these 17 sensitive noise receptors.
That's correct.
On figure 6-2, you depict acoustical contours attempting to show the limits of noise travel from your computer modeling, correct?
Those show the project only sound levels when the project is operating at its loudest.
I apologize. I think I'm referring to a different I'm referring to figure 6-2 now, 6-2.
Yes.
Let me just get to it. Is that up on the screen? Sorry.
It is.
Great. On figure 6-2, you depict acoustical contours attempting to show the limits of noise travel from your computer modeling, correct?
The figure shows the predicted project-only sound levels with the project operating at its loudest condition.
Why did you not depict the contours of the terrain itself? Isn't topography a relevant consideration when determining sound travel?
Topography is considered and relevant and is included in the modeling, which is stated in our report. I think if we were to try to show those contours and the sound contours, the figure would begin to get a little difficult to read, is one of the reasons we don't choose to show topographic information.
Actually, it's pretty easy to have an overlay, right? You have the existing topography, the little squiggly topography lines as basically your baseline over the property boundaries, and then you can easily put the rest of the data on, easily doing overlays of your computer generated figure, correct? Haven't you seen those commonly in sound reports, that the contours are depicted on the graphics?
No, because the intent of our figure is to show the sound results and to highlight what sound levels are produced by the project, not what the terrain of the surrounding area is.
And so if you didn't want to include it as like an overlay on this, that you had these boundaries depicted, how about another figure included in your report to show the contours? Because topography is a relevant consideration, right? Isn't that useful to have if you're trying to show graphically what the area is like?
Right. So in our report, we do state that elevation contours for the modeling domain were derived from data sets supplied by MassGIS, and it is included in the modeling. So all of this modeling in this figure is the result of site-specific and the surrounding area terrain. So it is included.
But we just have to take your word for it in the reporting. We can't look for ourselves about what you used or considered for topography, correct?
It's from a publicly available data source from the Mass GIS. It's a typical way that sound studies are conducted.
Right. Well, I looked at it myself, and you can correct me if I'm wrong, but the batteries, where you're going to locate the batteries, that's actually at the most depressed part of the project site, correct? It's almost like the bottom of a bowl. And then all the other areas and the sensitive receptors are up gradient of that facility, correct? Because I did look at the publicly accessible contours, and that's my impression of it as a layperson. Am I right or am I wrong?
I believe the site is generally lower in the area where the batteries are proposed, yes.
Did Epsilon sound level assessment include a prevailing winds study to check for downwind adverse weather conditions that would affect the surrounding area in terms of sound propagation?
So the acoustic modeling and this figure that we're looking at is generated by assuming that every direction is downwind simultaneously. So the modeling counts for downwind propagation.
Because you would agree that wind conditions can alter sound propagation levels by upward of 7 decibels over ambient, correct?
Wind can affect how sound propagates, yes.
And you took, as part of your study, and it's in there somewhere, but correct me if you don't think I'm right. You took a 48-hour wind speed samples on April 15 and April 16, 2024, correct?
For the ambient program, the sound levels are typically processed for wind and precipitation to ensure that we're only utilizing the lowest values that occur during calm wind and no rain.
Yeah, I'm asking, did you take 48-hour wind speed samples on April 15 and April 16, 2024?
I'm not sure if what you mean by 48-hour wind speed.
I mean, I got it from the information that I've seen in the record, but correct me. What wind speed samples did you take? Why don't you just tell me? What and when?
Collecting wind speed is part of the ambient program. So there was a device put on the site. We also did look at the wind speeds from the Worcester airport. But essentially those are, when we process the ambient data, we throw away any time period where it's too windy. And what we're left with is the ultra low quiet value that only occurs during calm conditions.
Okay, so then you don't account for windy conditions in which sound propagation might be higher, correct?
Well, during a windy condition, the ambient would be significantly higher. So the model propagates sound, assuming a downwind direction in all directions, but the ambient is measured assuming a very calm, quiet period. So that's one of the layers of conservatism that's built into our assessment.
Well, it's not conservative at all, right? Because if the amount of wind and being downwind of a noise source increases the degree of that noise source, it's going to make it worse, right, on the receptor.
That's correct, and that's why the modeling does assume that the receptors are downwind from the project.
Yeah, but I thought you said it assumes perfect conditions, not windy conditions.
That you're mixing up the ambient and the modeling. So we take our ambient sound levels during the ultra quiet calm periods, but then when we model the project, we assume that there is wind occurring and that everything is downwind. and we line those two up. So it's a very conservative evaluation with respect to wind.
I'm not mixing it up. That's what I'm asking you about. What did you do to test wind conditions? Like what did you use to factor in for that part of your modeling? High winds, low winds, no winds? What? I don't get it.
The modeling, the propagation that the modeling does adheres to an ISO standard, ISO 9613-2, and that standard propagates sound in all directions, assuming a moderate downwind condition.
Okay. And it does not assume any higher than moderate downwind condition, correct?
That's correct.
And what is the miles per hour of the so-called moderate wind figure that you put into the modeling?
I believe it's 3 meters per second.
Okay. Now on table 6, let me get this right. Now I'd like to look at the table, getting into the results now. So that would be at table 6-3. If we could look at table 6-3, please. And Mr. Callahan, let me know when that's up.
Yes, I see it.
With respect to PL South, and that's that monitoring location on the southern border of the property line, correct? PL South?
Yes.
That indicates an increase of 29 decibels over ambient, correct?
Correct.
And then next to that on the right side, on the column which indicates whether it meets Mass DEP limit, you indicate, quote, NA, close quote, and that means not applicable, correct?
Yes.
Now, and I'm sorry to do this, but just briefly, could we go back to figure figure 5-1? Is that up, Mr. Callahan?
Yes.
So first of all, just orienting us with the various figures, PL South that we just talked about, which ended up at 29 decibels above ambient, that is the monitoring location depicted as LT2 on figure 5-1, correct?
Yes, that's the closest monitoring location to that receptor.
Now that large parcel that abuts the project site south of the project site is privately owned, correct?
I believe so.
So, and then we don't have to flip to it. We don't have to flip to it because I'm going to read from it. And then if you want to refer to it, you can, Mr. Callahan. Looking at the DEP noise pollution policy interpretation, which is a 2-page document attached as Appendix A of your report, starting at page 30 of your report. On the second page, third bullet point, the last sentence of that third bullet point, it says the following, and I'm going to quote it. However, comma, a new noise source that would be located in an area in which housing or buildings containing other sensitive receptors could be developed in the future may be required to mitigate its noise impact in these areas, close quote. Is that consistent with your memory? I mean, you can look at it. Is that, did I accurately read that from the noise policy interpretation?
Yes.
In that case, quote, not applicable, close quote, is not an appropriate entry for the 29 decibel over ambient noise violation at the southern boundary of the property, correct?
Could you repeat that question?
Yeah. Considering what I just read from the noise policy interpretation, quote, not applicable, close quote, is not an appropriate entry for you to have made for the 29 decibel over ambient noise violation at the southern boundary of the property, correct?
No, because the Mass DEP focuses its criteria at the nearest inhabited residences and structures.
But what I just read is from the current version of the DEP noise pollution policy interpretation actually attached to your report, correct?
That's correct.
Okay. Despite that answer you just gave me, let me just ask you as an expert witness in this case, are you concerned about a clear noise level violation at that southern property line in light of what I read from the DEP interpretation, along with the fact that it is a privately owned property and not subject to no build restrictions, which might exist on the DCR parcels northeast to the project site?
No, again, because there is not an inhabited residence on that parcel.
PL North and PL East, those border DCR land, correct?
Correct.
And actually, then I'm going back to table 6-3, and I'm referring to, if you get down to almost the third to last and the second to last entries on the column have PL North and PL East. Do you see that?
Yes.
And those locations, again, I just asked you, but I'll just clarify, those border the DCR land?
Correct.
And that's why you listed not applicable on the issue of whether those locations meet the Mass DEP limit, correct?
Yes.
Aside from that, and I'm not claiming that they are subject to the policy, but just looking at the readings there, PL North has an increase of 20 decibels over ambient, while PL East reports an increase of 32 decibels over ambient, correct?
Yes.
And if those were subject to the noise policy, those would clearly be in violation, correct?
Those would be greater than the 10 decibel increase. Yes.
Now, if you look at, and I'm in the same table, fortunately, if you look at the projections for, I'm going to read these slowly, PL2, 3, 4, 5, 6, 7, and 9, those appear to be not that much farther away from the intended location of the batteries. And yet those projections of only 8, 7, 6, 6, 6, 6, and 9 decibels over ambient are reported, correct? In other words, between 20, 32, and 29 decibels over ambient.
I'm sorry, in other words, between what?
In other words, compared between 20, 32, and 29 decibels over ambient, those locations, PL 2, 3, 4, 5, 6, 7, and 9, have values of only 8, 7, 6, 6, 6, 6, and 9 decibels over ambient, correct?
Yes, that's correct.
Wasn't that enough of a discrepancy in terms of the location of where those are located to cause you to recheck something, either recheck your modeling or data or something to explain the wide variation between those decibel limits?
No, those locations are hundreds of feet further away than the property line location to the south.
Okay, so you're talking about just distance. In other words, you thought that those were so much farther away than these other locations that accounted for the discrepancy between 6 decibels over ambient and then the worst of 32 decibels over ambient, correct?
Yes, distance and terrain are both a factor for the differences in how sound propagates at this site.
Now on now we do have to look at the figure again. Let me get you through a right one. Just bear with me one moment. Okay, if you look at figure 6-1, can we put that back up and tell me when it's there, Mr. Callahan?
Yes, I see it.
Great. Now on the issue of distance, which you just used to describe the difference between those varying decibel limits, if you look at PL North, that appears, at least by eye, that appears to be the farthest away of the 3 locations where noise levels would exceed the 10 decibels over ambient, correct? In other words, compared to PL South or PL East.
Yes.
And what is that distance, and how does it compare to the distance of the closest of PL 2, 3, 4, 5, 6, 7, and 9 to the batteries?
So you're asking for the distance from the batteries to the PL North receptor?
Yes, exactly. Yeah. How does that compare? And looking at the figure, and I'm referring, everybody should really look at figure 6-1. Well, everybody, you can look at what you want as a free country, but Mr. Callahan, please do look at figure 6-1. I'm talking about PL 2, 3, 4, 5, 6, 7, and 9 to the batteries as compared to PL North.
Right, PL North is approximately 600 feet from the batteries, and the property lines that you just mentioned are a greater distance than that. I'd say more like 1,000 feet.
1,000 feet away, but 400 feet beyond the 600 feet, right? Not 1,000 feet more away than PL North, right?
Right.
And still, that discrepancy makes sense to you? Only another 400 feet causes the discrepancy between something that is, in the 20s and 30s above ambient, and then miraculously the other ones are slightly below the 10 decibel over ambient level. Is that what you're saying? The 400 feet accounts for that discrepancy?
Well, there's also terrain functioning here. And with respect to PL North, that is located closer to the transformer. So you can see that pink square, it's a very small dot there, which is located on the north side of the project. So yes, the terrain and the distance accounts for the differences that you're seeing, which are shown in the contour figure that we referred to earlier.
Okay. And now I don't think we have to look at the report for now. So we could take that off the screen. Of the 18 receptors you identify on table 6-3 of your report, for which you report that the noise policy does apply. There are 3 which project a noise level of 7 decibels over ambient, 6 which project a noise level of 8 decibels over ambient, and 3 which report a noise level of 9 decibels over ambient, correct?
Yes.
And that leaves very little room for error, correct?
No, because of the many layers of conservatism that are built into our study.
Well, acoustic modeling uncertainty typically is accounted for at 3 decibels plus or minus, correct?
There can be various uncertainty factors added to acoustic modeling, if that's what you're asking.
Yeah, in other words, they can be off a little bit. It's similar to when you see like a survey result reported in the news. 49% of Americans are in favor of X. And then they'll say, there's a 4-point gray area that could be plus or minus, right? Is it analogous to that?
With respect to modeling conservatism, essentially how that's accounted for is we simply add decibels to every source to over-predict, to ensure that we're doing a good job of predicting the project, showing its worst case, its highest possible sound levels. And then the model uses a very conservative set of assumptions which are built into the propagation algorithms.
Well, let me ask it a little bit differently. Is even a small error or a discrepancy in your modeling inputs could take you over the noise level maximums in areas where you project an 8 or 9 decibel over ambient, correct?
I don't know what you mean by small errors. Again, the model is extremely conservative. I'm happy to explain how and why that we're confident in those values. And then it's compared to an extremely low ambient level. So there's actually conservatism on both ends of the study that we've performed. The ambient sound levels that we're using to represent these locations, and then the acoustic modeling predictions that use very conservative assumptions with the equipment at the facility operating at its maximum condition, and comparing those two values together to arrive at these sound level increases.
Oh, then you disagree with me that a 9 out of 10 leaves very little room for error. Is that what you're saying? Your modeling is that precise?
Well, decibels use a logarithmic scale. So a change of 1 decibel is actually more than it sounds on paper when we think of things in a linear fashion. But what I'm saying is we are very confident in the modeling that we've done and the ambient that we've measured, that we've represented this in a very conservative way. And I doubt that we would ever even approach the levels that we're seeing in our report due to the conservatism.
And that conservatism didn't affect the fact that the 3 locations that you say are not applicable all well exceed the 10 decibel over ambient, right?
Not sure I understand the question.
Well, I guess I'm asking again. Are you saying that your modeling is that precise that in an area where some of your readings are, in excess of 20 and 30 decibels over ambient, and other areas in the same vicinity, same immediate vicinity, are 1 degree below, 1 decibel below the maximum of 10? You're saying your modeling is that precise that there's no room for error in those calculations. In other words, 9 out of 10 is absolutely ironclad. No one ever has to worry that it will ever exceed 10 decibels above ambient.
That's correct. The project has to comply with that criteria, and that is what our study shows. Just as an example, the project, the fans of the units can only operate at 40%, and that is the value that they would operate at when the ambient temperature is approximately 100 degrees. So we've assumed that the facility is operating at that hottest condition in the middle of the night at 2 a.m. and compared that value to the ambient level. So yes, it's a very conservative analysis that isn't likely or even possible to occur.
Have you conducted, and this not referring to this proposed facility, have you ever conducted post-operations noise measurements to check compliance with the Mass DEP noise policy at any 1,800 megawatt BESS facility or similarly sized facility?
Um, 1,800 megawatt is what you said?
Yeah.
This is Brian Benito from the project. I just want to clarify for the record, it's 180 megawatts, not 1,800 megawatts.
Thank you for the clarification. Yeah, 180 megawatts. My question stands corrected. Have you conducted any post-operations noise measurements to check compliance with the Mass DEP noise policy at any 180 megawatt BESS facility or similarly sized facility?
I am currently conducting such measurements at a facility in Massachusetts.
Is that Medway?
Correct.
But that's not in operations, right?
It is.
Well, that's under the commissioning phase, isn't it? You're not operating and generating and storing power at that, right?
It's not in COD, but it is in COD, excuse me, but it is operating and generating and storing power.
Well, wait, COD is what?
Commercial. It's commercial operations date.
You're saying that facility is not undergoing testing with regard to its startup, but it's in full operations?
So the commercial operation.
No, I'm asking the noise expert, not you. I'm asking the noise expert specifically. I asked you, have you conducted post-operations noise measurements to check compliance with the Mass DEP noise policy at any 180 megawatt facility? This is post-operations.
The Medway facility is a 250 megawatt facility, and we are conducting those measurements now in conjunction with the town.
Yeah, and that is underway, right? There's a review process going on, and there's peer review of your proposed methodology as opposed to the peer reviewer and all of that. There's not any measurable data coming out of that as of yet, right? You're still trying to figure that out about the protocols that will be applicable for testing.
That's correct.
Yeah, thank you. So with that clarification, have you ever done post-operations monitoring to determine compliance with the noise policy?
Well, I have been at Medway, and they have, during commissioning, been cycling the units, and I have conducted measurements. So yes, but not in an official capacity, which is about to occur for that project.
What does the town of Oakham do if the Moraga BESS facility ends up exceeding the 10 decibel over ambient noise limit at any of the residences in the vicinity of the project or at the elementary school or any other receptors such as those downtown?
The project has to comply with the Mass DEP noise policy at those locations. So if it was found to be out of compliance, it would need to mitigate until it complied.
Okay, so what does the town do specifically? Do they have to go out and make a case against you? What do they do? I mean, let's use a specific example. Say hypothetical resident Mr. Black, who lives on an abutting residential lot, complains to the town that this facility is so noisy I can't sleep at night, I want you to do something about it. What does the town do to try to seek compliance?
My understanding is that would fall to the Board of Health.
So then what would they do?
I can't speak to what the town's Board of Health would or would not do.
If I may jump in here on behalf of the town, my name is Brian Benito again. On behalf of the company, my apologies. As my subject matter expert here has testified, we, as the company, fully intend to comply with the Mass DEP noise standards. So these hypotheticals, I don't believe are really representative of what we're proposing. We are not likely to exceed the noise policy at 2 a.m. in 100-degree weather, which, as Mr. Callahan here has testified, would be the most conservative measurements that has been modeled in this study. So
okay, let me get a little then, since you want to sort of gild it that way, I guess we'll get into it a little bit. Okay, you've got readings on three. You've got readings on 3 of the 4 boundaries of the property that are well in excess of the Mass DEP broadband noise limit of 10 decibels over ambient. You have an excess of 20 and 30 in those locations. Then you have other areas that you miraculously have 1 decibel below the maximum 10. And those areas we talked about, you didn't put up monitoring or any of that. You didn't make any attempt to put any monitoring devices in there to get data from the field. And what I'm asking you is, say all your modeling is incorrect and your reporting is incorrect. And as you're in operations, you're violating the noise policy. What does the town do about it? I'm getting to a sort of a possession is 9/10 of the law, right? Once you're up and operating, what does the town do if it ends up that your numbers were wrong? You're over 10 decibels over ambient. What happens then?
So the company would be required at that point to adhere to the noise standards as outlined by Mr. Callahan.
So do you shut down?
Excuse me, sir.
Do you shut down?
Wait a minute. I'm sorry. Wait, I've got to hear the.
In order to accomplish that, we would look at additional mitigation measures to ensure that compliance is met. If we are unable to do additional mitigations measures to meet that threshold, we would then most likely have to curtail the equipment during those operating parameters where we're exceeding the noise limit.
And this is Evan Albert. We would request that the witnesses not be interrupted when they're in the middle of giving an answer.
This is cross-examination, counsel. I can probe him on ridiculous answers, and I can be a little bit rude when you're speaking so ridiculously on the record. Okay.
I don't actually think you're being rude.
I didn't interrupt him at all. This is cross-examination.
You did, because Mr. Brock said, I can't hear the end of the question and the end of the answer. So we're not complaining. We're just let people finish speaking.
I have been. I think we're done with this line of questioning. And it's up to you, Mr. Presiding Officer and the stenographer. If you want to take a break here, I probably have less than the amount of time that I've spent on so far, if that makes any sense. So to finish, and I can continue pressing on now, or if you want to take a break.
Yeah, I let me just confer with my colleagues here. Yeah, I think it would be a good time for us to take a break, and then let's take a break for 15 minutes. Resume at 11:58, and then we will have lunch approximately 1 o'clock.
Great, and I can definitely finish before lunch then with that break. Thank you.
Okay, and then yeah, if you finish before then, we'd probably take lunch earlier. Okay, very good. Thank you.
Thank
Off
you.
the record. Mr. Ferry, I can see you're there. We're not on record yet. Mr. Reich, are you back? I can see Mr. Pucci. I can see the company panel.
Mr. Rice is here. Yes.
Great. On record, please. Mr. Pucci, please resume.
Thank you. Mr. Callahan, when modeling for broadband sound levels to predict whether noise will exceed 10 decibels over ambient, you assumed that the megapack units are operating at 40% fan speed, correct?
Yes, that's correct.
And Mr. Presiding Officer, I have several questions pertaining to the redacted versus the non-redacted sheets from the report. I'm not sure if I'll do my best and then we can figure out if any of these, I can't tell if any of these have actually been in evidence. I know that the original redacted report is, but I'm not sure we ever actually entered as exhibits the partially redacted table 6.2 and then the fully redacted table 6.2.
Well,
6-2.
So nothing has actually been admitted in evidence yet. They're just being marked as draft exhibits, and then at the end of the hearing, we will have that discussion.
Okay.
And whether it's listed as a draft exhibit, whether the unredacted version is listed as a draft exhibit, I'm not sure, but that is my expectation that it would be included.
Okay. I'll just start asking questions, and we can figure out what to do. Mr. Callahan, you produced an unredacted table 6-2, which lists the per unit broadband sound decibel level for a Tesla Megapack operating at 40% fan speed, correct?
Correct.
Do you have that handy? And actually, let me check what you do have handy. I'm going to here's what I'm going to ask you about. I'm going to ask you some more questions about your report dated January 13, 2026. That's the one that we've been putting up on the screen. And then I'm going to ask you questions about the fully redacted page that's in that report. Then I'm going to ask you some questions about the fully unredacted table 6-2. And I'm going to ask you some questions about the partially redacted version of table 6-2 that was produced before that. Do you have all those documents handy?
I have the unredacted one, but I can answer your questions, I believe, because I know what the redacted ones look like as well.
Okay, great. So on the unredacted table 6-2, the number listed for the Megapack at 40% fan speed was from Tesla, correct?
Correct.
And you don't do any independent testing of that, correct?
We do not.
Did you do any modeling or were you provided any data from Tesla concerning per unit broadband sound decibel levels operating at a fan speed in excess of 40%?
The manufacturer's data includes sound levels at a variety of fan speeds, including fan speeds in excess of 40%.
But that's not listed on the report, right? On table 6-2?
Correct.
What was the maximum temperature that Tesla warranted it could safely operate at 40% fan speed?
I believe they indicated that 98 degrees Fahrenheit, it could be operated at 40%.
And for how long of a time? Like how many days can it be 98 degrees?
I believe it can operate as it's intended to function indefinitely at that value.
Okay. What happens during hot days in the summer when the outside temperature is at or near 90 degrees or more Fahrenheit, but the temperature inside the battery units themselves is much hotter, similar to any other sealed structure sitting in the sun on a hot and humid summer day, similar to a parked car in a parking lot?
My understanding is the ambient temperature of 98 degrees applies to the air temperature around the unit.
Right. What about the inside of the unit?
If the inside of the unit gets hotter, is that what you're asking?
Yes.
Then the fans kick on to cool the unit. That's why the fans exist.
Well, they'd have to operate in excess of 40% fan speed, correct?
No.
Well, let me ask you again. Say ambient temperature, I'm talking about if I'm standing outside, is in the 90s. But the sun beating down on a hot summer day on directly exposed equipment, sealed equipment, similar to a sealed parked car with the window shut, sitting in a parking lot. Isn't the interior of the battery structure going to be a lot hotter than the outside ambient temperature?
I don't have the answer to that. I just know what we have used for the fan throttle and what ambient temperature that corresponds to.
Okay, so then let me ask you, there was no data provided for that condition, right? Where you have ambient temperature, say it's only for one day, ambient temperature outside is in the 90s. And there's no information provided for, do you have to operate in excess of 40% fan speed if the interior of the battery unit is much hotter than the 90s outside the unit? Any information provided for that?
The manufacturer provided a response in one of our record requests. I'm trying to find which one it was, that indicated it could be operated safely at 40% fan throttle at the site.
Despite the fact that inside the units is likely to be much hotter than the ambient temperature outside the units on a hot summer day with the sun beating down directly on the units themselves, right?
Again, that's what the manufacturer has indicated, that when it's 98 degrees Fahrenheit, which is happening on a daytime period, they can operate at 40% fan throttle.
The BESS units themselves, the battery units, are not the only noise generating components of the project, correct? And referring to unredacted table 6-2, it refers to 3 sources of noise for equipment proposed for the project, correct?
Correct.
And those are, 1, the Tesla Megapack 2XL FN03 at 40%. Number 2, the medium voltage transformer. And number 3, the power transformer, correct?
Yes.
Before I ask you more about that, I want to ask you a little bit about this history on the redacted and unredacted production. Table 6-2 was produced 3 times in varying format. First, it was produced with all text in the document redacted, even the title of the table itself, which is table 6, correct?
Table 6-2.
Table 6-2. Even that is redacted from the original version of this produced, correct?
I believe so.
Yeah, let's look at it. Let's look at the exhibit. That would be, you can look at it. We don't need to put it on the screen. Bear with me 1 second. Let me just pull that page.
It's an NDA and not.
Okay, looking at the page that's actually in your exhibit, that's your report from January of 2026. Everything of the table is redacted, including the name of the table itself, which is table 6-2, correct?
That's correct.
All right. And then you produced a partially redacted, or I'm sorry. Oh, and before I get to that, that redacted version, you redacted everything in the table itself, even the title of table 6-2, both the title of the document and the fact of table 6-2. But then on the page is identifying information related to the report itself. Specifically at the top right-hand corner, it has OAK-381, then EFSB 25-07, page 22 of 34. And then at the bottom, it has information that's unredacted, which is 6970 Moraga Energy Sound Report .doc, page 6-4, and then Modeled Sound Levels Epsilon Associates Inc. You see that?
Yep.
Okay. Then you produced a partially unredacted table 6-2. And that has information for the medium voltage transformer and the power transformer, but blocks out the sound level information for the Tesla battery units as, quote, confidential. Then it goes on to provide information for the medium voltage transformer and the power transformer, along with footnotes 3 and 4, which list the source of the data reported for the medium voltage transformer and the power transformer. Is that correct?
Yes.
The sources of information listed in footnotes 3 and 4 on the partially unredacted table 6-2 appear to be publicly accessible publications which are not in any way confidential. So my first question on this to you is, why was this information ever redacted in the original January 13, 2026 report which you produced?
I believe that was an error on our part, which is why we then produced the partially unredacted. We over-redacted the entire table essentially, and then we corrected that by providing the partial redaction.
Then you produced table 6-2 a third time. This time with the Tesla information disclosed, but now renumbering footnotes 3 and 4 as new footnotes 4 and 5, and then adding 3 new footnotes. Footnote 1, providing further information on both the Tesla battery units and the 2 transformers, and footnote 2 and footnote 3 pertaining to the Tesla units alone, correct?
Yes, that was so that your consultant had the information that they needed to do their own modeling.
What was the reason either you or Tesla changed your minds about producing this information in unredacted format?
So we have an NDA with Tesla that essentially says don't share confidential data, and the sound data for the unit is labeled as confidential. But then during these proceedings, one of the emails produced by the manufacturer in response to another question revealed that sound level that we use. So because the manufacturer revealed it, I was no longer revealing it by providing it in an unredacted form.
You never reproduced your January 13, 2026 report itself though, right? Specifically, The document that's been introduced as marked for entry into the record is still stamped, quote, redacted on 28 pages of the total 34-page report, correct? I'm looking now at Oak 38-1. You don't have to count the pages. I'm telling you the word redacted is at the top of 28 pages of the total 34-page report. Is that consistent with your?
Yes, correct.
Yeah. And why is that? Why didn't you reissue the report?
Because the information had already been provided that was needed for the peer review, and the only thing remaining redacted was that one line of sound data for the Tesla unit.
Okay, so the original redaction stamps on this document, which has never been replaced, that refers to the originally fully redacted table 6-2, right? No other information has been redacted.
Correct.
All right. Looking at unredacted figures 6-2, both the partially redacted version and the fully unredacted version, neither of those versions have the rest of the identifying information contained in the fully redacted version in your original report. So if I go back now to page 22 of your January report, this page lists the identifying information that I identified earlier on the upper right-hand column and the lower column. Do you see that?
Yes.
Now, the partially unredacted and fully unredacted versions of table 6-2 have none of that information, correct?
Correct.
How do we know that the partially and fully unredacted versions of table 6-2 were the same as the table 6-2 in your original report?
Because I'm telling you that they are.
Okay. We already see that the later versions have different substantive information on the third versus the, wait. We see in the later versions that the 6-2 documents have different substantive information with new footnotes and changed numbering of footnotes between those two versions, right?
Yes, there were additional footnotes provided at the benefit of your peer reviewer so that they had all of the information they would need to conduct modeling.
There is no way of us sitting here today to confirm that any other substantive information was changed on the tables themselves, right? Between the first, second, and third versions that you produced, right?
I mean, I'm testifying that there were no changes, so I think that's the proof I can provide to you.
Well, why isn't the identifying information from the report itself, the marginal information containing, information as to what document it was from, the page number, what document it is? Why is none of that identifying information on the subsequent partially unredacted and fully unredacted versions of table 6-2?
I believe because these redacted versions were included in part of a full report, but then separately we provided the fully unredacted table as just an individual single-page document with the intent of providing all the information needed for the peer reviewer to conduct their analysis. And therefore it didn't have the same stampings and markings that the full reports had.
I'm going to make a request. I would like to see the page from the original, and this is a record request, Mr. Presiding Officer, and I'm not accusing anybody of anything. I would just like to look at this from a chain of custody standpoint. I would like the company to produce the original page from their January 13, 2026 report that contains table 6-2. I would like to see that original version. And the reason I'll know...
Can we have confirmation that there is an original unredacted version of that page as part of the original report? Could you ask that question?
Yeah, yes. Could you answer that question, Mr. Callahan?
So there is, and we provided it to the EFSB under protective treatment, and we will certainly put that into the record, if that's what you're asking, Mr. Pucci.
No, it isn't. I'm putting in a record request. I would like to see the page that was in the original report dated January 13, 2026. I would like to see the page taken from that report unredacted. And the reason that I'll know whether it is that or not is something I'll be able to check right away is footnotes on it, because those were changed in later documents. So if I, but that will only be the beginning of it. I won't be able to fully confirm it, but I would like to see the unredacted version that was in the original report from January of 2026. Not a substitute page that has different information and removes the page numbers from the document itself.
Understood. So this will be record request RR-OAK-4, and you're essentially requesting that page that contains table 6-2 that was submitted to the board, correct?
Yes.
Yep. Just that one page. Yes.
Yes.
Okay.
And then my final questions, Mr. Callahan, and just to bring us back, not to belabor the point, but Mass DEP noise policy, broadband sound levels. Mass DEP noise policy regulates both broadband sound levels and pure tone sound levels as two separate issues, correct?
Correct.
And pure tone can be sort of a hum that occurs continuously while equipment is in operation?
Yes.
Depending on circumstances, pure tone can actually be more intrusive than broadband sound levels, correct?
It's possible, yes.
For the Tesla Megapack units, table 6-2, the fully unredacted version, reports both, quote, broadband sound levels, close quote, as well as sound levels, quote, by octave band hertz, close quote, correct?
Correct.
And can you educate me? Am I saying that right? It's capital H, small z. What is that?
That's hertz.
Hertz. Yeah. What is that measurement of? What does that mean? What does hertz mean?
That's the frequency essentially. So how low pitch or high pitch a sound source is.
Great. And the second part of that octave band hertz refers to the pure tone part of the noise policy, correct?
The data in table 6-2 is used to evaluate the pure tone portion of the Mass DEP noise policy, yes.
Okay. And that is for actual equipment the company has selected for the project, specifically the Megapack 2XLs, and not battery units generally, correct?
For the Tesla Megapack 2XL FN03, correct.
Specific equipment with, warranty information and manufacturer information and all of that. Specific equipment that's been selected for the project, correct?
Yes.
And your fully unredacted figure 6-2 provides equipment specific information for the battery units, but does not provide equipment specific information for either the medium voltage transformer or the power transformer, correct?
That's correct.
Both the medium voltage transformer and the power transformer are also sources of both broadband sound input as well as pure tone sound output from the project, correct?
Correct.
So for the three sources of both broadband sound output as well as pure tone sound output from the project, 2 out of 3 are essentially guesses at the expected output, correct?
Well, the values for the medium voltage transformer and for the power transformer are based on an empirical equation. So it is a calculated sound level, and it's based on an equation that was derived by taking lots of measurements of those sound sources of various sizes.
But they're not specific to the actual equipment that will be selected and actually employed at the project, correct?
They're representative of that equipment. The specific equipment for the medium voltage transformer and the main power transformer have not yet been procured. So at that time is when you would get a sound data sheet indicating the exact sound level of those units.
And if those sound levels to the actual equipment chosen are higher than the input into your modeling, that would affect the noise policy compliance claims you listed on both table 6-3 and 6-4 of your report, correct?
It would impact the results of the study if they differed in either way, if there was higher or lower. And that's part of the reason that the modeling assumes all the conservatism that it does and the uncertainty that it does.
Okay, thank you. Those are all the questions I have.
So I am going to take a break for lunch. I wonder if we could break for 50 minutes, if that would be enough time for people, since we just recently had a break. Is that okay? 5-0. Okay, so we will resume at 1:15, please.
Thank you.
Off the record. Thank you. Mr. Ferry, are you present? Okay,
Yes, I am. Yes, I am, Mr. Keller.
Great. I see both you. I see Mr. Reich. Looks like the company is assembled, and I see Mr. Pucci. Are the Salpes present? I don't believe so. We will resume questioning now. I understand that Mr. Pucci is finished with his questioning, and we will move to Mr. Ferry, please, on the record.
Okay, thank you.
Okay, good. Thank you very much. Mr. Callahan, my name is Stephen Ferry, and I'm assisting Attorney Reich here, and we're representing the non-town interveners in this matter. Good afternoon. Let me ask you again. You mentioned earlier today in regard to questioning that you were first retained in February of 2023. Tell me when the first time was that you were able to take a look at this site. If not the exact date, at least give me an approximate date.
Sure, give me one moment.
Sure.
So we were on the site during April
of 2023.
April of 2024, I believe.
So the first time you or anybody else from your company was on the site was not until a year after you were retained?
I can't speak for everyone at my company because I just had involvement in the noise portion, but the first time that we were on the site to conduct ambient monitoring was in April of 2024.
Okay, thank you. Can you, or if not you, can somebody else from the company answer our question as to, in terms of how is the fan speed or the fan throttle controlled? Is it, in other words, is it done by software? Is it a mechanical device that puts a governor on the fan speed, or how is it done?
So the Megapack fan in the Megapack ramps up and down with respect to cooling demand of the unit. So as the batteries get hotter during charging or discharging, the fans ramp up and down accordingly.
Okay, and so obviously this could go to 100% fan speed, but how does it exactly, is it self-ramping? I assume it's to some degree automated then from your answer.
It is self, what's the word I'm looking for? It does that on its own, essentially, with response to the temperature of the battery.
Okay, so it knows how much cooling it needs to do. When you at least started at 40% fan speed or 40% throttle, how does it hold to that maximum if it does?
Again, it's just tied to how much cooling is needed at that point. In my experience, the fans will tend to kick on and off on any given moment. So they will ramp up and down. They will turn off entirely if they're not needed, and kind of everything in between.
And then how does it know to stop and not go to more than 40% of the throttle?
My understanding is that's a software control.
All right. So is that software that only Tesla can control? So once it's embedded, it's there forever, or is it something that anyone who let's say the company here could control if it needed to for any particular reason?
I'm not sure about how that is programmed or controlled. that would probably be a question for the manufacturer.
Okay, well, we already asked that question in an information request, and the company at that point elected not to respond to it. Can anybody else on the panel there respond to this at this point?
Yeah, yes, sir. This is Brian Benito from the company. We are looking for that IR right now. I believe we did address that.
Well, that would be helpful. I don't recall that you had, but so is the understanding here again that that is software that is, at least if you needed to control it, could you control it? If you needed more cooling, could you get more cooling out of it by more fan throttle? And then I guess this is back to Mr. Callahan or Mr. Benito.
Okay, so if I could direct your attention to EFSB -NO-9 parenthesis 1. In this here IR, you'll be able to see that I reached out specifically to address this question to the manufacturer Tesla. In the response that came back does confirm that the fans can be run at 40% without impact to the system performance at that recorded maximum temperature, as outlined by the weather station at Massachusetts Worcester Regional Airport.
Thank you. Yes, I recall that answer, but that answer did not answer our question then, or our question now a month or so later, is whether it can do it or not. That's not my question. My question is, who can set that fan throttle?
Yeah, so here, in addition, in this email, it says implementing this fan duty cycle cap will require a contractually defined operational constraint shown below, where any system damaging resulting from operation outside these conditions would not be covered by the warranty. So this is essentially saying, Tesla is telling us that if we want to put on this cap, this threshold, it would be contractually laid out between the company and the OEM to ensure that all warranties, O&M operations, and the like are adhering to that cap. As Mr. Callahan mentioned, this, in my understanding, would be a firmware or software implementation on each battery.
And when you say if we wanted to do it, it sounds like that is at least controllable by the operator. Putting the warranty aside for a minute, is that correct?
I cannot answer that at this time. I can just speak to what Tesla told us, and it would be something defined within our contract. That contract and that definition within the contract would lead to, my understanding, a firmware or software patch or implementation within the actual BMS, the battery management system,
Okay.
or TMS. It would be defined that way.
Understood. Yeah. So basically, this is controlled by the TMS to some degree. Is that correct?
The temperature, correct?
Yes. Okay. Good. So, and again, the issue, are you aware that the issue of whether this violates the warranty or doesn't go to the question as to whether a party can or cannot do something. It just means that a warranty, which is a guarantee of certain things, is conditional on certain things to do and not do.
I'm sorry, could you repeat the question, Professor? I missed it there.
Yeah, okay. So in other words, I understand that I remember the answer here that it to stay within the warranty, you need to operate in certain ways. But a warranty is a second promise or a second guarantee in addition to the basic exchange of here's our equipment for this amount of money if you purchase it. Again, violating the warranty does not mean you can't do something, right? Is that correct?
Violating a warranty would put the project at significant risk, and likely void many other contracts that are associated with this project, primarily our financing requirements associated with building and constructing this project.
Okay, and your financing is coming from Segway, or is that only the equity?
The project will be financed through a multitude of ways that I can't discuss here publicly.
Okay. Okay. Let me ask you about construction noise for a minute. Is the construction noise going to be significant at the property boundaries? And I think you were asked earlier today about some of the properties to the west of the bordering the project on the west side where the driveway comes in.
I believe we provided predicted sound levels at a variety of distances.
You did?
From project equipment. So if we were to look at that, we could get an idea of what the sound levels would be at those closest property lines.
Okay. So you, for example, in response to, I think it was our interrogatory number 16, or our information request, I'm sorry, number 16, you had specified before it was 85 decibels at, I think it was 50 feet, and we asked you to go up 100 feet, 200, 300, 400, up to 1,000. I believe you responded at 1,000 feet, it was 59 decibels. Does that sound about right?
Yes, it does.
Okay, good. And so what would that be approximately at some of those property boundaries? Some of those property boundaries, some of those residences I think we established in our prior hearings were in the vicinity of 1,800 feet. Again, if you look at the information that you provided us, it's going down in 1 decibel increments. At 700 feet, it was 62 decibels. At 800 feet, 1 less, 61 decibels. 900 feet, 1 less, 60 decibels. 1,000 feet, 59 decibels. Does that mean the construction noise would be slightly lower than 59 decibels at those property boundaries, which are probably slightly over 1,000 feet, but not much more?
Yes, I think that's a reasonable estimation.
And do you have any sense as to how that compares to background ambient noise? Of something in the vicinity of the high 50s, 59-ish decibels.
Sure, it would be above the existing background noise, but something in the 50 decibel range would be quieter than typical conversation between two people.
Okay. Did you, what were some of your, if you take a look at the range of your measurements, what were some of those background levels? As I recall, you had some night background levels on that property, if I recall correctly, and you're free to correct me if I don't recall correctly, in the range of, at night, 25 decibels.
Yes, well, there wouldn't be construction going on in the middle of the night.
Understood.
I'm sorry, I didn't hear the end of the sentence. There wouldn't be construction going on in the middle of the night. What?
That was the end of my response.
Okay, thank you.
Yes, and I understand that. But what would be a reasonably low at certain times of day background level during the day from your measurements in that general vicinity there? And I know you're out on the road, and there were earlier questions from Mr. Pucci sort of saying, aren't you picking up a certain amount of road noise? But again, tell us on one of those properties what that might be, if not on the road, at least in the middle of their property.
Sure, so we have graphs of sound levels that were measured at the long-term locations. So if I were to look at the average sound level, for instance, at LT1, which is the location closest to the homes along the road, during the day, the average sound level is typically in the 40 to 50 range.
Okay. So, and if you had, again, something, if the construction noise is at 59, that's at least above that to some degree, correct?
Correct.
Okay. What is the range of additional noise that can come from the medium voltage transformers? I know we've just established that you haven't picked those out yet, and there's obviously a range of options there. But if I recall correctly, there are, for the 184 megapacks, there were planned to be 46 of those. For those operating alone, what is the range of decibel output that those make?
I'm not aware of the particular range of all the possible transformers that could be selected, but the equations that we've used to represent them, anytime that we've seen a real spec from a transformer that's actually built and has a sound study performed, has always come out lower than what our equation assumes, because it's a conservative assumption based on the size of the transformer. So the manufacturers will typically produce them to be quieter than what that spec reveals.
Okay. And noise is additive. I recall that Mr. Pucci was asking you about the three noise sources, both from the megapacks, the medium voltage transformers, and the major power transformer. But those are basically additive, are they, if they're operating at the same time?
Yes, it's a cumulative sound level of all of those pieces of equipment operating simultaneously at their maximum sound levels.
Okay. And is it true that all three of those would typically be operating at the same time, that is a fairly common instance?
When the site is charging or discharging, then yes, all of those sources would be operating simultaneously.
Okay. So tell me more as to when is a likely time, or maybe let me just ask you the question, maybe that would be quicker. The cost of wholesale power is cheapest oftentimes in the evening. So oftentimes it'll be from 11 a.m. at night to 6 in the morning or something like that, when the cost of requiring wholesale power to store is dramatically lower than other times of the day, because demand is also lower with our locational marginal pricing system in ISO New England. So isn't it true that some of the recharging is likely to happen in those hours when the power is most abundantly available and cheapest?
Yes, I believe so.
And then again, is it also correct, just for starting out here, that oftentimes when one is discharging is when power is most needed, therefore the value of the power is more to the system as a whole? And that there were former questions about hot days. Isn't that often at the hottest times of the day when we need more power for air conditioning and other requirements?
Yes, it could be.
Okay. And then, so those might be times when there is, when all three elements of this facility, in terms of the battery storage, the medium voltage transformers, and the main transformer, would all be operating.
Correct.
Okay. Let me ask you this too. What is the maximum number of battery storage units that were modeled in your work for this project?
In our current report, we are showing 184 Tesla megapacks. In a previous version, we had modeled, I believe, 212 megapacks.
Correct, and that's what I recall also from prior testimony. Tell me more about how additive the sound is. So we've established at least that these three components of sound are likely to be all operating at a time of charging and discharging, and talked a little bit about when this might be occurring. Obviously 212 battery storage units is more than the 184 that are now planned. Do those also bring more of the medium voltage transporters with them, transformers with them? I'm sorry. When you add batteries, do those come with it?
Yes, I believe they do.
Okay, so we're adding two of those three components of sound. And you've modeled that, as you said before, I think at 212. How much of an increase was there in sound pressure from the 212 versus the 184?
I believe it was only about a decibel or so difference between those two scenarios because of the logarithmic nature of how decibels add and subtract.
Okay, so again, 212 is, I have to do the math here quickly. That would be what, 28, is that roughly 28, I think, additional battery storage units? Did I do that right? I think so. 16 and 12, yeah, 28. So that would be roughly an addition of 28 battery storage units to the 184. What happens if that number is larger than that? What happens if that number is double that again? So instead of 28 additional units, it might be what would that be, 56 units, something like that. What does that do to sound?
If I may hop in here, Professor, this is Brian Benito from the company.
Sure. Sure.
So the scenario you're laying out there where we would be adding more than the 212, and the question relating to the noise associated with that top up, if you will, is not a scenario that we are proposing. And the reason why we haven't asked Mr. Callahan to model that is because we have a cap at what we can actually put onto the regional bulk power system. That cap is at 180 megawatts. So there would be a scenario where there wouldn't be a scenario where we would go above that 180 at the point of interconnection.
And where does that cap come from?
That cap comes from the ISO New England interconnection study that we are currently in the late stages of right now. Essentially, what that means is the regional transmission operator, ISO New England, looks at our project and determines what our project can inject into the existing system. And then they compare that with all the other folks that are also trying to do the same thing. And that determines through that very elaborate study how much energy is actually going to be able to be put onto the system from our project. And we have determined in pre-studies and have submitted to ISO New England a 180 megawatt cap.
Okay, let's go back a bit here. So I know this has been an issue not only with battery storage, but with solar and other projects as to who gets to use what percentage of the available capacity on the line. Isn't it possible if some other projects do not go forward, whether they're solar projects on this line or storage projects on the line, that would free up capacity for other entities to use some of that capacity?
That is correct. However, that is not the project that we've put forward, and it's not the project that has been studied. So therefore, it's not a viable scenario for the project as proposed here in these hearings.
As of today, yes, understood. Okay. Again, Mr. Benito, when you and I had a chance to talk at the first day of hearings 10 days or so ago, we talked a little bit about some other sites, and there are certainly other parts of this of the communities immediately, I shouldn't say immediate, but proximate to Oakham, where there are proposals to substantially upgrade the lines. Are you aware of that? In other words, to put more capacity and higher capacity lines in place?
I am not aware of that.
Okay. Isn't it also possible, though, that with all of the modeling that National Grid and other utilities are doing, that one of the proposals, since electricity is expected to be used more for more purposes going forward, that lines could be upgraded?
That is, lines get upgraded every day, sir. Yes.
Okay. And just going back to our first day of testimony, when you and I were talking at page 68 of the transcript on line 14, we had a discussion about how much additional pad was being created here for the overage for auxiliary or additional battery storage units. And we had a discussion here. I think we talked about how if there were 44 more units added, that would be more than 212, that there was space for that. Those could be added. They could either replace existing units, or perhaps they'd just be added and the existing units would remain there in case extra power was needed or was capable of being produced. One of the questions we asked is, I actually took out my ruler and tried to measure the site diagram. If I'm recalling correctly, I said, it looks like you've got much more space than less than 24% increase of only 44 additional battery units on this pad. Isn't it close to 50% greater than that, but perhaps in the 30 to 40% range? And I believe you agreed with that. Isn't it possible, at least in terms of the pad, I understand it's not your plan today and it's not your proposal, but isn't it possible still that there could be not just 212 units, but perhaps something closer to 250 units in terms of what the pad would tolerate there?
I do not believe that's possible.
Because?
Because we're seeing in the industry, these OEMs, these original equipment manufacturers, are consistently making the batteries more dense. That allows us to augment with fewer batteries to ensure that we maintain the 180 megawatts as outlined in our interconnection application. Okay, so in other words, the current proposal that doesn't contemplate that at all. Is it? Is the company taking the position that it will never increase the amount below 180 megawatts of charging and discharging capacity as part of this facility? Sir, the company's taken the position that we've applied for 180 megawatts at the POI, and speaking in nevers or hypothetical 100 years from now is not appropriate for me to do. So I feel it's best for me just to stick to what we've put before you all in this proceeding, which is what we've applied to the bulk power system operator ISO New England, and that's 180 megawatts. All right. So in other words, again, it's ISO New England's capacity that is limiting this at the current point, right? It's a little more nuanced than that, but sure, yes. Yeah. Okay. Good. Thanks. Okay. Let me go back to Mr. Callahan for a minute here. So tell me again, if one were, let's talk a hypothetical again. If one were to add 44 additional battery storage units to the 184, again, about how much does that raise the decibels if you count both the additional medium voltage transformers, which would be multiple of those, and the additional battery storage units, and they were all operating simultaneously?
That's not a scenario that we have evaluated, but what I can say is, regardless of the format of the project, it would have to meet the criteria of the Mass DEP noise policy, and therefore the sound limits would have to be met.
Does that DEP noise policy, is that basically applied everywhere? So that is basically the absolute limit that they tolerate?
I'm not sure I understand your question.
So basically, that's sort of the maximum limitation that they have for noise augmentation or noise increase at any parcel is 10 decibels, 10 dBA.
That is the allowable increase per the Mass DEP noise policy. Yes.
Yeah, anywhere, right?
In the state of Massachusetts.
In the state, yeah. Good, yeah. I understand it. Can you just give us just a generality so we know what we're dealing with here? We understand you're only modeling this at a 40% throttle on the fans. How much increase is there if we went up a notch, or if these Tesla, not that you go up a notch, but how much of an increase is there if the medium voltage transformers and the were running and we were at a 60% fan throttle? How much more does one get? I understand you're not going that far, but what's the delta of additional noise?
I believe The 100% condition is approximately 10 decibels louder than 40%. So a 60% condition would be somewhere between that. So it's likely a few decibels. It's probably 3 or 4 decibel difference from a megapack to megapack standpoint.
Okay, thank you. Give me a minute here. I'm hoping to cut out some of my questions here. And again, let's talk about what the decibel increase is. What is 10 decibels? What does 10 decibels do to the amount of sound that's perceived? Is that double?
A change of 10 decibels would be equivalent to approximately twice as loud. But with respect to the Mass DEP noise policy, when we're talking about a change to the ambient, what we're really predicting is what the change compared to the quietest 6 minutes of an hour is with the project operating at its maximum. So it's important to understand that a 10 decibel increase over ambient is not really the same as turning something up or down by 10 decibels, like your television. If you take your remote and turn your television up to the point where it's twice as loud, you have changed that sound level by approximately 10 decibels. That puts it into context.
All right, and so and again, contrast that with the measurement that you were doing in terms of affecting ambient.
Right, so the ambient sound level uses a metric called the L90.
Right.
And that metric, if you take a sound level reading for a 1 hour period, the L90 is representative of the quietest 10% of that 1 hour period. So that means it's the quietest 6 minutes of that hour. And it's also important to understand that those 6 minutes are not the quietest consecutive 6 minutes. It's the quietest 6 minutes integrated over that entire hourly period. So it is a true residual sound level. If a car drives by during that 1 hour measurement, the L90 is essentially blind to that event. So we're starting with this ambient sound level, and then we're calculating what the potential for that to be increased is.
Okay. Let me ask also, as long as we've got the panel here, I know I asked you earlier when the first time was that Mr. Callahan was able to go on the site, and he answered that. When is the first time in the panel's knowledge that the company ever got access to the site or was able to visit the site? And again, it doesn't have to be an exact date, but can you give me an approximate date?
This is Mark Bergeron. July 21st, 2023 was the first documented time from reviewing my records that someone from Epsilon Associates was on the project site to perform a contracted activity.
Okay, and did I hear that was, you said July 21st, 2023?
That's correct.
Okay, and how do you, again, this is private property. How do you what do you do? Do you have to notify the owner before you go on private property?
At this point in time, it was our understanding that our client, the company Rhineland Holdings, had permission to be on site and have representatives on their behalf on site. So the procedure for us to be on site was to check in with at the police department in the morning. At that time, in July of 2023, there was a lock on the gate, and the key for that lock was left at the police department. So our field personnel had to go and check in there, obtain the key, and then get onto the site, and then again lock and return it at the end of the day.
So does the owner have to do something to tell the police that it's okay for just consultants coming on the property can get on it?
I'll let the company speak for itself, but our understanding was that that was the arrangement that the company had had organized with the landowner and then again locally with the police department to make sure we could get on site.
So is that in the original agreement that we've discussed that gave some degree of control to the company over the site?
I don't know. I'm not a party to that agreement.
Yeah. I mean, again, I'll just say to the hearing officer, we've got a standing request obviously out there to be able to look at that document. I think it was indicated in an earlier hearing that would be provided with the price redacted. And of course, we have no problem to redact the price. And I'm not sure that has been provided yet.
Mr. Presiding, just let me know if this is Attorney Pucci. I object to anything being redacted from it. We have a standing motion to compel. If we're talking about the purchase and sale agreements reflected in the option to purchase that has been produced, we're still seeking that in unredacted format. I just want to be clear on the record on the town's position.
Thank you. Thank you. I guess we are not quite as concerned about the price, but unredacted would be fine with us too. So let me ask you. Let me ask you this: Does the owner at that time when you're out there on the site for the first time in 2023, are they aware that you're out there to evaluate the site potentially for the BESS facility?
Perhaps I should jump in here, Brian Benito from the company. Our contract with the landowner allows us, as well as representatives of ours, to access the site. As you indicated, Professor, it is private property and it is posted. So it's our understanding and that of the landowners that folks would not just access the property without some sort of agreement in place and or some sort of notification. So this line of questioning to Epsilon and Mr. Bergeron and Mr. Callahan would fall between us and our access agreement that we have laid out in that option to purchase contract.
Okay, let me ask you this since we haven't seen it. Does that access agreement basically say that the company is buying that option for purposes of a battery storage facility?
I don't have the option contract in front of me right now, but we have been very clear in our intentions, and we are exclusively a standalone battery energy storage developer. So it would be my expectation, if I were to be looking at that purchase agreement right now, that it would indicate Rhineland, and Rhineland is a standalone battery energy storage developer.
Yeah, so that would be clear to the owner at that point.
It would be clear to the owner, and it was clear to many folks. Yes.
Okay. Well, let me pursue that then for a minute. And I'll come back to Mr. Callahan in a moment, if I may. Are you aware that Mr. Cohen, was Mr. Cohen the owner of the facility, or was he representing the owner of the facility, Mr. Yaniv Cohen?
Yes, I believe he was indicated on those applications as a principal of the company of the ownership of the property. Yes.
Okay. Here's something I guess that I want to follow up now. So if you're out there doing the first due diligence and consulting work out there in the middle of 2023, Mr. Cohen went to a planning board hearing in Oakham, and at that hearing, he said there was no effort whatsoever to put a battery storage facility, or no plan to put a battery storage facility on the site. I believe his exact words, and this is going to be in 2024, were that there is no intention of building battery energy storage on this site. And since you also indicated that in 2022 you were in control of the site, what kind of control was being exercised to allow that to be stated at that point by anybody?
Professor, I would not feel comfortable speaking on behalf of Mr. Cohen or yourself or anybody else. So I do not know when he said that or why he said that or if he said that.
But you testified earlier that you had control of the site in 2022.
That has been presented in the hearing, correct?
Yeah, okay. All right, so I just wanted to try to understand a little better, since we haven't seen the document, what that control was or how it was being exercised. Let me go back, if I can, to Mr. Callahan for a few minutes more. So let's go back to the thermal management system again, the TMS, and that operates autonomously, and it basically is trying to keep the unit cool, which obviously is extremely important. Again, it adjusts on what factors? Again, it adjusts on ambient temperature.
I'm sorry, again, at what?
I'm sorry. Again, does it adjust in part on ambient temperature? Let me ask that to Mr. Callahan.
Yes.
And does it also adjust, the thermal management system, does it also adjust based on the intensity of the charge or the discharge cycle?
I'm not sure I can answer that because I don't know enough about the internals of the software control, but I can say that I have stood next to this equipment while it is charging at maximum rate. And in a cold environment, the fans essentially either don't kick on at all, or they kick on to a very, very low level, such as a 10% or so.
Okay, so it is responding at least somewhat to the charge or the discharge cycle.
Yes, it definitely does respond to the charge and discharge cycle.
Okay. Okay, give me just a second here. Okay, let me just help Mr. Brock out if I could. I'm going to use a term, joule, and just for purposes of transcribing this, that is spelled Joule in this sense. Let me ask you, what is the joule heating loss in these batteries as they age?
I do not know that.
Okay, are you familiar with the degradation of batteries and the joule heating decline in these batteries that you're proposing to use?
I am not.
Is anybody else on the panel familiar with this? I mean, you're selecting a battery here, and this is of some significance.
Is the question that batteries will degrade over time? Is that the question, Professor?
Yeah, it's that they do degrade over time and the consequences of that.
Yes, yes, sir. We are familiar with the fact that the batteries will degrade over time, hence the discussion we were previously having about the need to potentially augment at a later date.
Okay, so let's talk about this. Again, it's basically called the joule heating of the batteries. Again, Joule for the record. So why do the batteries degrade? What is happening inside those batteries?
So I'm not in the position to explain battery chemistry. Unfortunately, that is not in my area of subject matter expertise. However, it's a well-known fact that your cell phone battery, your car battery, all batteries do degrade over time. So I think it's like, as Mr. Pucci likes to say, it's a common sense thing, but I don't have a degree in battery chemistry, unfortunately.
Okay, okay. And again, let's go back to Mr. Callahan for a second, if I can. So your modeling of the noise here is based on the same, since you're using the Tesla data and inputs for some of it. Is that based on the same? Is Tesla's data based on their same new batteries that you're proposing to purchase, the 2XL?
Can you clarify that question?
Yes. So in other words, the data that you're getting from Tesla is when they take one of their new batteries and measure some of the inputs that, or give you factors for some of the inputs you're using in the model, correct?
That's correct.
Okay. And so, again, Mr. Benito just mentioned that they are aware, or the company is aware, that these batteries degrade over time. are you, is anybody there, from Mr. Benito or Mr. Callahan, are you aware of, again, the rate at which these batteries decline after year one?
To be clear, I am aware of that. It is outlined in Tesla's warranty and service contracts. However, do not have that information in front of us. But that is something that Tesla tracks and the industry is well aware of. However, it's not something that I'm able to speak to in terms of what that percentage would be year over year.
Okay. Are you aware that batteries develop hotspots, that these particular batteries develop hotspots inside the, inside their metal containments where the heat is higher?
But I cannot speak to, I do not know that exactly, no, sir.
Okay, is anybody else on the panel aware of that? Are you, well, I'll wait for an answer.
No one on the panel is aware of that, sir.
Okay, thank you. All right, so are you aware that the degradation requires them to charge and discharge less efficiently because there's internal resistance to the movement of the ions across the anodes in the battery?
Yes, I am aware of that.
Okay. And again, you go ahead, I'm sorry.
It's specifically called the round trip efficiency, an RTE.
Good, thank you. All right. Are you aware that that RTE is a nonlinear equation, that gets worse over time and is often described as a J-shaped or U-shaped, but typically J-shaped curve of increasing loss of efficiency?
I have not seen the J or U-shaped curve. However, I have no reason to doubt your description of it.
Okay. Maybe we should describe it this way. Are you at least aware that it is nonlinear? We've talked about exponential things, both in terms of heat and other things earlier here that are not nonlinear also. I'm sorry, in terms of noise, to say noise or nonlinear. Are you aware that at least it's a nonlinear? In other words, on each charge or discharge, the efficiency could get less.
As I mentioned, my understanding of efficiency is around what Tesla and the contract lays out, and I believe that's presented as a year-over-year efficiency, not a cellular or subpart of a cellular efficiency level.
Okay, but it does increase over time, correct?
The round trip efficiency does decrease. Yes, correct. Yes, sir.
Okay, good. Thank you. Okay, so would it be fair to say here that the lack of efficiency is because what the battery is doing is it's creating waste heat as opposed to as efficiently storing electricity?
I do not know the answer to that, but I do know that Tesla has one of the best round trip efficiencies in the industry, as well as one of the longest warranties.
Okay, agreed. And again, but what are you at least aware? Let me ask this differently. Are you aware that the battery runs much hotter over time? And this is internal to the equipment that you're installing. The battery runs hotter over time because of the loss of efficiency. In other words, it's producing more waste heat. If we come back to that question,
I am not aware of that, sir.
So you're not aware that the battery runs hotter?
I'm aware that the battery has very high and low operating temperatures that it can operate at. However, I'm not aware of how hot it gets as the efficiency decreases over time.
Okay. Are you aware that the battery can become as much as close to 50% hotter over time as it ages in its useful lifetime?
I am not.
Okay. Is anybody else on the panel able to speak to that at all?
They are not.
Okay, thank you. Are you aware also that as the C rate, the so-called discharge rate, is faster, the discharge rate of the battery is faster, that it is sometimes accused of accelerating itself. It's often called the heating spiral, but it basically increases the resistance in the battery, and therefore the fact that the battery gets much hotter much faster. Is anybody there able to speak to that?
Nobody here can speak to that, sir.
Okay. Are you aware that as the increase in the C rate, the discharge rate increases, it does not increase the basically the heat generation in a linear fashion, but it does it by the square of that increase in the discharge rate? Is anybody familiar with that?
Not familiar with that, sir, but what I am familiar with is with regard to noise, regardless of how hot or cold it gets, or how fast it gets hot, or how slow it gets hot, we have committed to be in compliance with the Mass DEP noise standards. And as such, it would be our expectation that the battery would operate within those parameters to ensure that compliance, regardless of C curves or U curves.
Okay. But again, we mentioned that the data that you are using, or taking from Tesla to use here for modeling, I'll go back to Mr. Callahan. The data you are using, I think you just said, is based on new equipment. So what we're modeling here is brand new off-the-shelf equipment. That's what Tesla's modeling. That's what you're inputting. They're not taking older or degrading equipment in some years out. And so it looks like we are looking in some degrees in terms of the best case scenario for internal heat generation from battery degradation. Am I wrong on any of that?
We are using data that the manufacturer provides at a specific fan speed, and then we have been told that it will operate at that fan speed at this site. If it operated at a higher fan speed, which it is not going to, if it operated at a higher fan speed during the day, for instance, which we didn't do a specific analysis of that because we're already showing that it will comply using a 100-degree scenario at night, all of our increases would be substantially lower. So even if the fans spun faster than 40% in the day, it would still comply according to what we see. That theoretical.
So tell me that again. You're saying that if the fan does run faster than 40% in the day?
The ambient sound level increases during the day as compared to the middle of the night, which our entire analysis is based on the quietest hours of the night.
Right.
And Tesla has indicated that these units can operate at 40% for this site, and that's all they need to go to. But the sound data from 40% to a higher throttle, such as 50 or maybe even 60%, are only a few decibels, whereas the ambient would increase by more than that. So what I'm saying is if the fan throttle were higher than in a theoretical scenario that we're discussing here that is not being proposed for this project, if the fan spun faster than what we modeled during the day, it would still comply because the ambient would outpace the increase in sound of the Tesla unit.
Okay, well, but again, it's not modeled at anything else, right? So does this indicate? I mean, this is, I guess, somewhat important, just because I suppose everybody would prefer that one controls the heat, which can be an issue with battery, as opposed to just holding the fan speed down. It sounds like the machines, if they need to cool it, could go up higher than 40%. Does the thermal management system basically look first and say, we've got to keep this cool? Because again, we're talking about two things. Mr. Pucci earlier asked you about the sun beating down and said inside these containments, it could get hotter inside. Now we're saying something else. We're saying as this ages, there could be, and I'm not asking you to agree that it could be as high as a 50% increase in heat production inside the batteries, but there could be at least some significant increase in heat inside the batteries, regardless of what the sun's doing. Are you saying that the system, at least to protect against fires, would be able to take the fan speed up to cool as necessary?
No, no, I'm gonna jump in. No, sir. What we're saying is that we asked Tesla a specific question as to whether or not this would be able to operate safely and within the safety parameters outlined by that OEM in the design and manufacture of the battery at 40% at 100 degrees approximately. What we've modeled is that scenario happening at, let's say, 2 a.m., the quietest time of any day, and typically also not the hottest. So the answer to your question, Professor, would be Tesla has some pretty smart people that work there, and it would be a high likelihood that if we asked them if this could operate at 40% fan at 100-degree temperature, that they would know all of the U curves and J curve scenarios that you were laying out in this line of questioning, and would in turn say yes or no, it could do that with that understanding of their own equipment.
But you don't have any independent verification of that other than Tesla telling you we think you're okay.
I have contracts that will be executed with them that will lay out these operating parameters that we're discussing here with regard to noise and 40% fan speed.
So what does that mean when you say lay out the operating parameters?
It will lay out that the fans will be operating at 40% speed, as outlined in the email I read earlier.
Yeah, no, I recall the email that you read, but the operating parameters. So is that basically what you do to, again, is that just to preserve the warranty on this?
No, sir. As I've answered now a few times, Tesla's batteries can operate in Antarctica and they can operate in the Mojave Desert. We have asked Tesla, can they operate in Oakham, Massachusetts at 40% fan speed? They have come back and said, yes, it can. What I'm trying to simply share with you, sir, is this panel here and myself included don't know much about the J curves and the U curves, but I want to put on the record that we are very confident that Tesla is familiar with what you're asking and would have already taken that into consideration when they answered our question with regard to the fan speed.
So is there anything in that contract that you're mentioning that guarantees any protection to the town? In other words, does their warranty cover the whatever could happen if for some reason there was a runaway event or something else, and it didn't handle it didn't handle any of these heat sources? So we've got heat sources from charging and discharging. We've got heat sources from degradation of the batteries, where waste heat is produced, and we've got the sun that Mr. Pucci asked about. Is there any third-party guarantee for the town? The town's potential loss here if something bad happened has a lot of zeros attached to it.
Yes, so just to be very clear, we do not have a contract in place with Tesla at this time.
Oh. Okay, so
we have not purchased the batteries at this time.
So have you seen a model contract? Do you know what that contract does or doesn't do, or is that still not even on the drawing boards yet?
We would not have access to a model contract, as those are typically specific to the unique nature of the companies that are operating between those two contracts.
Okay. Would you,
for example,
go ahead. I'm sorry.
So for example, our model contract would not potentially be valid for someone else in Phoenix, Arizona, because our contract would have a 40% firmware limitation on the fan. So therefore, if they were to review our contract, which they wouldn't be able to, they would not be an apples to apples comparison there.
Okay. Well, assuming that an important variable here is to make sure that this system operates safely, noise is important too, but certainly safety is an important issue that I know other witnesses will speak to. What are you intending to ask Tesla to do to protect the town in the I don't know whether it's likely or unlikely, but in the event that there is an error here related to heat in the system or other problems that have occasionally occurred to these buildings.
Yeah, Professor, I think it's important to note that, we are going to be working through this, and we'll be collaborating with the town and our safety expert who will be testifying on Friday. And much of that will be laid out in the ERP. As also indicated in this hearings, we will be carrying a sufficient amount of insurance to cover any of these catastrophic, unlikely events. Additionally, we've also put forward and supplemented here recently the global failure rate of these Tesla Megapack 2XLs, which is very, very low likelihood. In fact, only a handful globally have actually had the failures that we're talking about here. So I want to be responsive to your questioning, sir, but I would also like to say that some of these questions would be best suited for Friday's subject matter expert rather than the noise expert and the stormwater expert that we have here today on the panel.
Okay, yeah, okay, I understand. But let's just follow through with this. Obviously, it's going to be your and the company's decision as to protection levels or whatever we want to call it. You've talked about just a second ago. You mentioned the company would want a sufficient amount of protection, which I guess would be insurance. What is a sufficient amount for Oakham?
Sir, we've outlined this in multiple IRs. I don't have it in front of me now, but if you would like to wait, I could flip through to find those responses, or I could perhaps after a break tell you exactly where they are.
Yeah, or maybe we could even take a break and you could flip through and read them back as to what's a sufficient amount.
If you wait one moment, we'll just check it right now. So
okay. That would be great.
Professor, if I could direct you to EFSB-G.
I'm sorry, sir. I couldn't understand you. What?
Sorry, Mr. Brock. If I could point you to EFSB-G-15.
Is that 15 or 1.5 or something else?
15.
Thank you.
And does that have an amount in it?
Yes, the coverage amounts here are $2 million for commercial general liability, a $10 million plus umbrella policy, $5 million environmental liability, $1 million workers' compensation, and $1 million automobile liability. It's also important to note, in addition to these coverages, all of our contractors, the EPC, Epsilon, and the like, they all carry their own insurance as well.
Yeah. Once the facility is operating, though, I would assume we're relying principally upon the company's amounts that you just announced. Is that correct?
That would be accurate.
Okay. How does $10 million cover sufficiently a town that has we'd have to go back and look, but let's say approximately 1,000 individual parcels in it, real estate parcels?
I don't understand the question, sir.
How many? Okay, if there were, let's think about worst consequences here for a minute. I don't want to describe them, but I guess we can all sort of imagine what they would be. And you mentioned that there is some evidence of a few problems here and there and other projects. How many lot owners can be covered if the maximum insurance is $10 million?
I don't understand what you mean by lot coverage of 10.
Well, I mean, what is it?
I'm sorry, I didn't hear the end of what you said. I don't understand what you mean by lot coverage.
That was it, Mr. Brock.
Okay, thank you.
Well, I mean, it's possible in certain places that individual loss of, let me back up a step. many of these policies that are general liability policies will have a certain amount for the loss of the structure, and oftentimes as just a ballpark, it'll say, and 50% more for personal belongings, something like that in these policies. If if a given house is destroyed and somebody loses their house and their personal belongings, it seems to me that $10 million doesn't cover very many of those. Is that an unfair assumption? I'm basically saying that's interesting, but it's not a huge amount, it appears to me.
I believe that's an unfair assumption, Professor, because as our subject matter expert has testified here and as the data has shown, it's highly unlikely for an event on this project site to therefore impact residences over 1,200 feet away. It should be important to note that, since it was already brought up in this hearing today, Medway, it should be important to note that Medway and many other facilities of similar size and scope are within feet of residence houses. So this site has been highly de-risked from the scenario that you are attempting to lay out here.
Okay. Let me ask this question. We've learned only once the hearing started here about additional entities that are involved. So we have, am I correct that this is going to be a limited liability company that operates this?
We are a limited liability company, yes, sir.
And it will be a project-specific company, right? So it's going to only have the Oakham facility.
Moraga Storage LLC is a project-specific limited liability corporation.
All right, thank you. And then we learned earlier in our first hearing that also Rinland is involved. And I think we also, from your testimony, if this is Mr. Benito, learned that Segway is going to be involved in perhaps multiple capacities.
That was actually part of the record long before the hearing started, but
all right, okay. All right, good. All right. So are you willing to provide a letter of credit because limited liability companies often that are project specific don't always survive if there were some sort of a unexpected event? Would you be willing to provide a letter of credit to residents and the town as a whole? Which is a surety. Let me just explain it. A letter of credit is a surety. It has a third-party entity with substantial financial assets and not just a specific LLC stand behind certain promises or certain guarantees in an arrangement.
Good. Yeah, sir, I think what we're willing to do and what we've repeatedly said throughout this hearing is that we're focused on ensuring that we're going to continue once the town is willing to. We're going to continue to work with the town and all the stakeholders to ensure that this site is constructed and operated in accordance with all the regulations, standards, codes that are applicable. So with regard to committing to a letter of credit, as you're asking with the abutters, that is something that we would certainly be willing to discuss outside of this proceeding. However, I'm not in a position right now to talk about how many abutters or folks. This is a very hypothetical thing that's very challenging for me to address in this proceeding. So I would like to reiterate that we've got a draft ERP that we are very eager and willing to begin working with the town to execute. We have decommissioning plans. We have HMAs. We have all of these processes and procedures that are in draft form that we are eager to begin working with the town and all stakeholders to ensure get executed appropriately so that this project can move forward and provide the benefits that we all know it can provide to the Commonwealth of Massachusetts.
All right, thank you. I know Mr. Reich also has a few questions on this, so Mr. Hearing Examiner, I might yield to him if that's appropriate.
That would be fine. Thank you, Mr. Ferry.
So I believe am I unmuted? Am I correct?
I can hear you.
Okay. Mr. Gallagher, can you hear me?
Yes, I
Hello?
can.
Okay. So I had a few questions to direct to Mr. Benito and others. Let me just grab my notes and so this is directed, I'll direct it to Mr. Benito, or it's yeah, I don't know who submitted it. It's EFSB 25 -07, and it's RR EFSB 9 parens 1. I can put it up on the screen unless Mr. Kelleher, one of your DPU people, can put it up on the screen. EFSB 20, I'm sorry, EFSB 9 parens 1. It's a record request.
Yeah, we will put that up on the screen.
Okay. So it's a 2-page document.
Yes, we see EFSB dash, we see the record request, yes.
Okay. So
Mr. Reich,
yes, I want the
Mr. Reich, just in the interest of ensuring that you're getting your answers the way that I think you want to get them. This was not prepared by anybody that's at the witness table here today. This was prepared by Chief Sean Morris, who will be testifying here on Friday.
So you're saying that nobody here at the table today can testify to this document, correct?
Correct.
But Mr. Morris can testify to it.
This is Mr. Morris's record request. Yes, sir.
Did Mr. Morris prepare the table that we're talking about?
Yes, he did, as with all the other record requests that he's identified as preparing.
All right. So I'm happy to defer to Mr. Morris, but again, I've been through this rodeo once with you, Mr. Benito, when you said that a certain traffic engineer would have certain information, and then it turned out he didn't have the information. So I just hope that I hope that Mr. Morris will have that information, because otherwise we're deferring to you, and then we're getting no information on Friday. So that's your representation, to Mr. Morris.
Mr. Anderson is here, and he can answer all of your questions.
Mr. Anderson, sorry.
Yes.
Okay, that's fine.
Sorry,
I want the assurance about Mr. Morris.
Wait a minute. One at a time, please.
I want the assurance about that Mr. Morris will be able to testify to the chart that is shown at EFSB 9 parens 1.
Yes.
Okay, thank you. So I have another question about a document that was in that document, by the way, was submitted, I think, on or about March 16th into the, for whatever reason, it wasn't submitted till about March, I believe on March 16th. Next, I had a question about an exhibit that purports to be a Tesla manual, and it corresponds to RREFSB 8 parens 1. And that also was submitted, I think, as late as Monday of this week by the company.
Mr. Reich, I would hate to do this, sir, but this was also prepared by Chief Morris, who will be here on Friday. Who I have here with me today is the traffic swept analysis, Mr. Anderson, as well as stormwater. and Mr. Callahan for noise. Unfortunately, Mr. Pucci had asked that Mr. Chief Morris come back on Friday.
Well, I'm happy to do that, but this is directed more to you, Mr. Benito, or to the company. And that is, I've looked at this Tesla exhibit. It has a number of representations about hazards, how to handle hazards, the types of hazards that can come from a best facility. It has a lot of statistics in it, a lot of details in it. None of those have ever been provided to my mind in response to any information request or otherwise submitted into the record. And I'm asking why someone from the company can tell me why was this exhibit not filed until the second week of the hearing, second or third week of the hearing, third week of the hearing.
Could you please be more specific on the lots of hazards that you see in the document?
Yes, it refers to hazards from mechanical damage, hazards from leaked coolant, hazards from leaked refrigerant, hazards associated with leaked electrolytes, hazards associated with vented electrolytes, emergency procedures, and so on and so forth.
Oh, perfect. Thank you, sir. Yeah, so appreciate you pointing that out. So those particular hazards, as we've discussed, will be addressed in the emergency response plan. So that would be something that we've been, reiterating that we're willing to and able to, and looking forward to working with the town on to complete that documentation, which is currently in draft form.
All right. Well, that was not the question I was asking. The question I'm asking is, why does a document like this Tesla exhibit that was filed on or about Monday of this week, why was that exhibit and all the details in it about potential hazards of a best facility not provided into the hearing record until 3 weeks into the hearing, when we'd already, examined Mr. Morris, we'd already examined you, we'd already examined a number of witnesses, and now we finally get this document 3 weeks into the hearing? That's my question.
Mr. Egg, I don't know if I have an answer you're going to like, but we have answered all of the record requests, all of the IRs to the best of our ability. That particular document you're looking at there was in response to a record request to Chief Morris. But what I can say is that, these particular things that you've listed there, again, will be identified clearly in the ERP and the HMA. Which Chief Morris will happily be able to talk further about and more eloquently than me on Friday.
This is Evan Albert. Mr. Reich, if I could, just for the clarity of the record, this document was produced in response to a record request that was asking for a version of this document that specifically addressed or specifically referenced the battery chemistry type involved here. But there was a prior version of this document that's been in the record for quite some time.
And what is that prior version?
I'll find you the exhibit number. It'll take me a moment. You can go on if you want, and I'll get it for you.
Right. Well, was that document identical to this document, the prior?
I can get you the exhibit number. I think I just mentioned it was not identical. It was a prior version of this document.
All right. Well, without knowing what the prior version says, it's a little hard for me to, again, to have an answer to the question of why wasn't something with this amount of detail in it produced earlier. So let's wait until you can find that EFSB document.
So that exhibit number is EFSB-S-39 parens 1.
Sorry, what, EFSB-F or S?
S as in snake.
Yeah.
39 parens 1. The response to that request was submitted on January 29th, 2026.
Okay. And is it possible to put that document on the screen?
I am not connected to the Zoom link. I don't know if the EFSB staff could do so.
Yes.
Thank you.
I see it on the screen.
Hold on. Okay. Is it possible just to go down to the table of contents? Okay. I'm not going to try to skim this and question you. I will look at this at the break, and then we can resume questions about that document and whether it was fully produced before. So, Mr. Keller, your assistant can take that down now, and I'll go into another line of questioning with Mr. Benito. Thank you. We'll come back to that. Okay.
And let me just ask, so there's been the indication that some of the questions you've asked will be better answered by the safety expert on Friday.
Yeah.
And is this line of questioning about why a document wasn't produced earlier, can that be just as efficiently addressed on Friday as it could be later today?
Yes, I'm just raising it, and I'm certainly happy to readdress it to the company when Mr. Morris is there. Okay.
Okay, so we will save questions regarding those two documents that we've referenced in the last 10 minutes for Friday.
Okay, thank you.
But it sounds like you have additional questions as well, so go ahead.
I do. Mr. Benito, I believe you testified, I think the first day you were here, that you didn't join the company, didn't join Moraga until sometime. Well, you tell me, just refresh me. When did you join Moraga?
I joined the company approximately the middle of February of 2025.
Okay. Are you familiar with the GEI report?
I'm sorry, I couldn't hear you. You dropped out.
Are you familiar with the GEI report that we had some testimony about, dated 10th, 2023?
I'm sorry, dated what?
August 10th, 2023.
I am aware of it, yes.
Okay. And are you aware that Mr. Bergeron, Epsilon Associates, contracted with GEI to prepare that report?
I am aware of that, yes.
And was that report prepared? And you know, did Mr. Bergeron make that request on behalf of Moraga?
Make what request, sir?
The request to have this GEI do a due diligence review.
No, sir. We requested Mr. Bergeron to take on that additional scope.
I understand. So the quick answer is yes, the company did request Mr. Bergeron to do an environmental due diligence review, or contract for an environmental due diligence review of the prior report by, I think it was CWAS. Is that correct?
SWCA, yep, yes, sir.
SWAS, CS, yes. Okay. So, Mr. Bergeron, sorry, Mr. Benito, are you aware of that report, the environmental due diligence review?
Yes, as previously just testified, I am aware of that, yes.
Okay. And again, this report, first of all, is this report already on the record?
Yes, it is.
Okay. Do you have a date of when it was put into the record?
I can look it up here in a moment.
Okay. So while you're looking it up,
Evan's got the date. Record request date for GI.
We just submitted.
while you're looking it up,
It was last one.
is it true?
Last,
Is it, sorry?
sorry, it's response to a record request. We're gonna get you the exact date. It was either last Wednesday or Friday.
All right, last Wednesday or Friday, okay. So again, Mr. Keller, perhaps now is the time to ask the company, why is it that that wasn't put into the record until last week, Wednesday or Friday, when the report was dated 2023, and therefore in the possession of the company, consultant for the last 2.5 years?
It was the report was basically a summary. So the SWCA report was contracted by another entity. So what we did was we asked Epsilon to summarize that report, to refresh it, if you will, which is very standard for environmental phase 1 site assessment when you're going through with a land transaction. In fact, these need to be refreshed periodically to ensure that everything within them is still the same, which was in this case.
All right, so define what you mean by refresh.
Essentially, that report was provided to us by the landowner, and we provided it to Epsilon and asked them to ensure that that report was put together in accordance with ASTM, and to ensure that there was nothing in the report that we may have missed in our due diligence.
So
This is Mr. Bergeron. If I could just add as well, I believe that the SWCA report, if I remember correctly, was in response to an information request that asked for the company to provide all phase 1 site investigations that were completed. And, you know, I don't want to split hairs, but the due diligence that was completed is not by GEI reviewing the SWCA phase 1, not in itself a phase 1. So we were just trying to be responsive to the request for phase 1s.
I think it's partially in hairs because Mr. Benito has said that he wanted somebody to refresh the earlier report. The earlier report did some sampling at the site. In the environmental due diligence review prepared by GEI, it says, we've prepared this letter summarizing our environmental due diligence findings for the following properties. 2 of them are redacted, and one of them that's not redacted is 358 Coldbrook Road, Oakham, Mass, which is the project site, correct?
That is correct.
Okay. In the executive summary, GEI says in bullet 1, it is GEI's opinion that there is a potential that recognized environmental conditions could be present in the portion of the property that Rhineland is interested in. So I guess I'll put this question to Mr. Bergeron. What is your understanding of RECs, or recognized environmental conditions? What's the definition of that?
I'm not a licensed site professional, but if you'll allow me just by my definition of what I believe they are,
yes,
based on my experience in the environmental field for 30 years, they would be based on a variety of things. So that would be if there are any known releases that have been documented on a site over time, any cleanup actions that are within the Massachusetts Contingency Plan, the 21E program. It would also be based upon site investigations or soil samples, any known reportable concentrations in soil or groundwater, or any suspected land uses that show an imminent threat of release to the environment based upon field assessments by a licensed site professional.
Right. So when the report says it's GII's opinion, there's a potential that recognized environmental conditions could be present in the portion of property the Rhineland is interested in.
I'm sorry, I can't understand you. The portion of property, what?
that Rhineland is interested in. In layman's terms, does that mean they're stating that there's a potential that could be contamination present in that portion of the property?
Sure, I can clarify. In response to this record request, the due diligence report that you're looking at, which is GEI's review of the SWCA Phase 1 environmental investigation, which is dated, I believe, May 2022. They reviewed that. They also, at the time, when we were contracted to do this work, we talked about this last week, I believe, the initial area on the 42.9 acre project site that Epsilon Associates and their team were contracted to initially look at was a 5 acre portion of that 42.9 acre site in the southeast corner. So what GEI was stating in their due diligence is they reviewed the SWCA site, report, which actually did not include a look at that 5 acre forested area. So what GEI was doing was they were recommending to Rhineland at the time that additional review needed to be done on that 5 acre portion of the site. And so they went out and did a site assessment on that portion of the site. And that was the second attachment in that record request, their observations of that 5 acre area that wasn't actually covered in the SWCA Phase 1 investigation.
All right. I don't know if you have access to the GEI report in front of you.
I'm sorry, you're dropping in and out. I don't know if you what.
Please.
And so, report.
So,
if not,
sorry, I'm sorry, Mr. Rice. You're dropping out a whole lot.
I feel like dropping out at this point. So let's go back.
Mr. Rice, we might have to have you call in again to correct the audio problem. Or, Mr. Rice, you could also try turning off your audio, your video, and see if that helps.
I'm happy to do that. Let's see.
And we're doing that. This is Mark Bergeron. We are trying to get a hard copy of the document. We just don't have it printed because it was just submitted.
Yeah. Is this any better, Mr. Block?
We will see.
All right. Let's try this again. Mr. Bergeron, can you hear me?
Yes, I can.
All right. Mr. Brock, are we okay?
For now.
For now, good. That PEI report, there's a statement. I'm going to read it into the record. Mr. Brock, if you can't get it, I'll have to call in. Please note that the limited site investigation effort did not include any investigations of the portion of the parcel that is under consideration for purchase by Rhineland.
Yes, I see that. It's on page 3 of that document.
So following up on that, the investigation that was done by I'll never get this right, SWAC, the prior site consultant, involved an investigation of a very different part of the site. Is that correct?
So as indicated, this is Mr. Benito, as indicated there, and as I mentioned before, part of our due diligence, we were provided the SWCA report. We asked Epsilon to look at that report to ensure we weren't missing anything. This highlighted area that you just read into the record showed that we were in fact missing something per that review of the SWCA report. Once identified, we then contracted to have that missing portion, approximately 5 acres in the southeast corner, reviewed.
And how far in distance is the portion of the site that SWAC investigated and took samples at, and the portion of the site that GEI looked at?
SWCA reviewed the entire area that was consisting of used automobiles.
Okay, you didn't really answer my question. How far distant is that area that was being used for salvage of used automobiles? How far in distance is that particular part of the parcel from the part of the parcel that GEI was asked to investigate?
Sure. It's immediately adjacent. I think that, you know, what Mr. Benito was trying to explain, that I think does actually help identify what was looked at by SWCA. So SWCA focused on the portion of the 42.9 acre site that was in active use for the auto salvage yard. So when you look at the site plan or aerial photographs submitted with the petition, you'll note that there's about a 5 or 6 acre area outside of that in the southeast corner of the parcel. And they did not look at that in May 2022.
Right.
So what GEI is trying to identify in their report on page 3 is that they just wanted to be clear that they were due diligence. They didn't do a phase 1A, which you could also say is a limited site investigation. They wanted to be clear that they didn't want to misrepresent that they did any of those things. They reviewed SWCA's, and on page 1, you'll see in the executive summary, they made 2 recommendations. 1, to complete a targeted site visit to observe conditions on that 5 acre portion, the forested portion of the site that was not recently actively used for the auto salvage yard. And they recommended that a limited site investigation may be recommended. So an additional phase 1 on that portion of the property. Rhineland then contracted us to do the targeted site visit, and that's the results that you see from their site visit. I believe is dated September in that record request, and nothing further was completed by Epsilon or any of their subcontractors related to site characterization or investigations.
Would you be willing to provide the scope of work that was part of the communication Rhineland had with you, Epsilon, regarding this GEI or regarding any, further site investigation, A, and B, would you be willing to provide your scope of work that you gave to GEC to do its
So that you gave to GEC?
GEI,
Sorry?
GEI, to give to GEI to perform their site investigation?
We actually have in this response. So the report that you're looking at, the August 10th, 2023 report, very clearly reiterates the scope of work that GEI was contracted to complete throughout the report in detail.
And where do I find that?
It's the entire document, essentially. It's section 1, section 2, specifically the scope of services. Actually, I would point you to that after looking at it. So scope of services, GEI explicitly cut and pasted their scope of work to be clear of what they were and were not doing as a licensed site professional, and what they were representing and what they were asked to do and what they did.
That's the entirety of the scope of work that you provided to GEI?
Yes, it is. Because if you walk through those steps, it lines up with what I just explained GEI did, and I just walked you through their entire scope of work, what they did, what they recommended, and where we concluded our services related to hazardous materials investigations on the site.
All right. In the request from Rhineland to you to have the prior report of SWCA looked at, did they have the same scope, or did they have a different scope for you? What did they ask you to do? Go ahead.
I mean, they asked us to do an advanced due diligence and to essentially do exactly what we just lined out and what's bulleted out here. We did what they asked us to do.
Did they ask you to do any further site sampling?
They did not contract us to do that.
Okay. Were you ever put under any limitation from Rhineland to not do further site sampling, have GEI not do any further site sampling?
No, we're not contracted to do anything beyond what I explained.
No, I'm asking you whether, you know, in writing or in communications with Rhineland, you were put on any under a restriction not to do further site sampling.
No, we're not obligated to, and we were not restricted. We basically presented our recommendations that you can see here in this report, or GEI did on the Epsilon team's behalf. And
I'm sorry, or GEI did what?
On Epsilon Associates' behalf as a subcontractor, and we were not asked to provide additional scope.
Okay. As an environmental consultant, isn't it true that if you have a parcel of property that has been already tested for certain contaminants, and you then are trying to have that report reviewed, that it's appropriate to do further sampling, knowing that the area that they sampled was not the same area that's going to be adjacent to or underneath the best project? Wouldn't it have been more appropriate? Wouldn't it have been not more appropriate? Wouldn't it have been appropriate to do further sampling, knowing that sampling was not done in the direct area of where the best site was going to be located?
Well, I'll let Mr. Benito speak to the company's approach, but just you asked me a general question as my experience as an environmental consultant. There are different approaches as far as how you time out your investigations and how you manage risk, and different clients manage risk differently and can perform these types of investigations at different intervals in their project development phase. Again, I think that our review of the SWCA report and the site walk showed that, although there were some potential, and we did recommend some additional investigations, it seemed like it was a fairly low risk. Again, we recommended to Rhineland that we could provide them with additional services when they were ready and when their timing was right to do so, based upon their assessment of risk on the site.
Did you ever make a recommendation in writing or orally to Rhineland that they should do additional sampling to that done by the prior consultant, given that the prior consultant had not investigated the direct area of where the best was going to be located?
Well, in writing is based, so the August 10th report.
I'm sorry. Well, in writing, what?
Specifically, the August 10th, 2023 report that we've been talking about, completed by GEI. GEI did recommend some additional action items. So we did present that in writing, submitted this report to the company. And at the time, Mr. Benito wasn't there. I told our contacts that we'd be happy to develop some additional scope if they wanted, if and when they were ready to pursue that. And those conversations have yet to materialize.
All right. So is it fair to state that there's been no further sampling of the site of the proposed BESS facility done on behalf of or directly by Moraga or its parent?
That is fair to say, yes.
Okay. And going back just a little bit, since we have not yet been provided with the prior agreements for control of the site, I think this is probably for Mr. Benito. When you got control of the site back in 2022, sorry, what portion of the site did you get control of? The entire 42 acres or only a portion of those acres?
Is the question in November 2022, did we review a portion of the site or the entire site?
No, my question is, in the agreement, in the amended agreements of 2022 and respectively 2024, since you've not provided us the agreement, I don't know what the answer to the question obviously is. So my question is, what portion of the site did you contract for land, for land control with the owner of the property?
Yes, so we, as has been mentioned multiple times, we have control over the 43-acre parcel.
All right. So when the site, when the GEI was contracted by Mr. Bergeron's company to examine the site, who limited them to the 5.9 acres or whatever it is it will be occupied by the BESS facilities?
So there was no limitation there. That 5 acres that we scoped for review was based on the recommendation that came out of GEI's review of the SWCA site investigation, which precluded a portion of the property which GEI identified to Epsilon, who then identified it to us, in which then we realized we hadn't had a complete picture of the 43 acres from a due diligence perspective. And then we contracted to complete the record for the entire 43-acre parcel to be having a limited environmental site assessment and environmental site assessment.
All right, so Mr. Benito, and you still have an agreement in place for site control over the entire 42.9 acres of the.
That's correct.
Yes?
That's correct. Yes, sir.
Mr. Reich, let me interrupt briefly.
Sure.
I would like to take a break very soon. If you expect you'll finish in the next 5 minutes, I would let you continue. Otherwise, I'd like to take a break now and have you finish after the break.
I'm fine to take a break.
Very good. Off the record. And we will reconvene. Let's reconvene at 3:15.
Mr. Keller, if you're there, I'll be back in 1 minute. Thank you.
All right, it looks like all the attorneys are back. Mr. Reich, would you resume on the record, please?
Yes, thank you. This is for either Mr. Benito or Mr. Bergeron. I've seen the response, which I think is labeled INT 1(2). And if I'm correct, it consists of, let me just get this in front of me. It consists of 3 pages. It's called a field observation report. That's on page 1. It has and then it has 2 pages of site photos. Is that correct, Mr. Whoever, Mr. Benito or Mr. Bergeron?
I'm sorry, we're getting that printed off. I believe you're referring to a record request.
This is in response to record request RR int 1(2). It's the second part of the REI report.
We're getting a hard copy sent to us, but I'm looking at it here on council's computer.
All right. Is Mr. Bergeron there? Yes, I see you are there. So is that a 3-page report?
It is.
Are there any other pages to this report that are missing?
There are not.
Okay. I don't see a summary of the observations other than we did not observe indications of releases or potential releases of oil or hazardous material during the site walk, and see site visit photos. Is there anything else to the report other than what I just read?
No, there is not. That was the entire report with the photos.
Did anyone from the company, including you, Mr. Bergeron, working for the company, have any communications with GEI after the date of this this observation, which I think is dated September 19th, 2023?
I've had communication with GEI repeatedly since then, but not on this project, but I
No,
guess.
I'm referring to this project.
Yeah, again, these were their observations, so I'll bring it back to the August 10th report.
Yep.
And they made 2 recommendations for this site, right? They said we should do a targeted site visit.
I'm sorry, we should do a what?
A targeted site visit to observe conditions on the forested portion of the property. And then they said a limited site investigation may be recommended based on the findings of the site visit. So following the conclusion of their September 19th, 2023 site visit and this field observation report that we submitted, GEI again recommended a limited site investigation based upon the findings from reviewing the SWCA report and these field observations. And as I said earlier, nothing further was done, or we were not contracted to do additional work related to hazardous materials assessment on the site.
So I think I've already asked an answer, but just to get it back on the record. So GEI did not do any actual sampling of soil or groundwater at the site we're talking about. Is that correct?
That's correct.
Good. Did they make any recommendations to you or the company to do any further site investigation after they submitted their report and their field observation report?
They came back to the findings and their suggestion in the August 10th and reiterated that they would recommend additional limited site investigations as project development move forward.
You say they would recommend?
Yes. as summarized on page 1 of the August 10th, 2023 report. So the field observations completed in September confirmed, and they still recommended, made the same conclusion to Rhineland, that as they move forward in project development, they would recommend additional limited site investigations.
Well, so now I'm a little confused. The site visit was done on September 19th, 2023. Am I correct?
Correct.
The report that we're referring to, the environmental due diligence review, is dated August 10th, 2023, correct?
Correct.
So you have a statement under executive summary, bullet number 2, a limited site investigation may be recommended based on the findings of the site visit. Are you saying that subsequent to the issuance of the field observation report and of this earlier August 10th due diligence review, that GEC has indicated that they will recommend a limited site investigation going forward?
Let me be clear. So what I'm saying is that GEI made the recommendation for limited site investigations in August. They also recommended to complete a targeted site visit to that portion of the site that SWCA did not look at. They went out there on September 9th. You see the results of their report. You asked me just previously if after their September 9th visit, they made any additional recommendations in writing. They did not. At the time, we were having either weekly or bi-weekly project team meetings. GEI popped on the meeting after their September report came out, and Rhineland said, well, you didn't see anything, what's your recommendations? And they again reiterated their same recommendation from their August 10th report, which is, as you do go forward and continue development of this project, we recommend that additional limited site investigations are recommended. We were not contracted to do so. That was the end of the discussion on that matter.
All right. So that was made in the presence of
I'm sorry, sir, you're dropping out. So that was what?
that recommendation made in the presence of a company representative.
The recommendation was provided to the company in these reports that we've been talking about.
So I just wanted to clarify it because, you know, when you were referring to a recommendation was in a report dated August 10th, and then you seemed to indicate that GEI also said, as the project goes on, we will be recommending site investigation, further limited site investigation. So just to confirm, so they did recommend to the company we should do a limited site investigation.
Yes, sir. Yeah, this is Brian from the company. Yes, sir. With all due respect, sir, we've said that they've said that to us now for over 10 minutes. We don't understand where this is going, but we're trying to be responsive to your questions that are the same questions. Yes, they replied in this memo that you have that we recommend to do a phase 1 in the future.
So, Mr. Benito, the company has had site control since 2022. Am I correct?
That's correct.
Okay. And they've had site control over the entire site.
That's correct.
Okay. And since 2022, the company has done no site sampling of the groundwater, surface water, you know, any aspect of the site in terms of a typical site investigation to investigate environmental conditions. Am I correct?
That's correct.
When, if ever, do you intend to do a site investigation that would include sampling of the groundwater, soil, and any other portions of the property that might be contaminated?
Those limited site investigations as recommended by GEI will be conducted as development of the project progresses.
Will that be before or after this hearing concludes?
After this hearing concludes.
Okay. So is it fair to say that there will be nothing in the record of this hearing that will reflect the results of that, whatever sampling you do?
That would be accurate if we have not scheduled a project, an ESA at this time. That would be accurate, yes.
All right. So the people that are listening to this hearing from Oakham, the EFSB and anybody else that has an interest in the property can safely conclude that there will be nothing. Strike that. Is it fair to say that the EFSB will have no information about the actual conditions of the area where the BSS is scheduled to be sited? We'll have no information about the quality of the soil, groundwater, strike that, soil and groundwater at the site during this hearing.
I don't think that's accurate. The EFSB and the public have the reports we've been talking about here that do lay out a bit about what's going on in that particular area. That being said, as part of a normal process of development and of real estate transactions, an ESA will be conducted on this site in the future. Were there to be anything that's found during that ESA by an LSP, we would, of course, then ensure that we are in compliance with the MCP, excuse me, if applicable.
Mr. Benito, in your various capacities over the years in different companies, have you ever been commissioned by the company or requested by a company to assist them in doing due diligence on a prospective purchase of property or another company?
Yes, my first job out of university was to conduct environmental phase 1 ESAs on behalf of a consulting company that I worked for, on behalf of a client that was a large real estate broker interested in purchasing additional properties throughout the country.
All right. And in your capacity in that job and any subsequent jobs, have you ever recommended to your client or the company you're working for that they should require some sampling, that is testing of ground and groundwater at a prospective purchase site?
That can be certainly recommended, as was in this particular case that we're discussing here.
Well, it wasn't recommended by you to do any sampling of this particular site. Am I correct?
Sir, A, I wasn't with the company when this report was done. B, the company, the LSPs that did this on our behalf recommended that to us. We've taken that understanding of the site and the risks associated with not doing that to date. And we've determined that we will be doing an environmental site assessment per the recommendations in the GEI report at a later date and further down in the development of this project.
Mr. Benito, have you ever heard of the concept of willful blindness?
Objection.
Sustained.
Mr. Benito, isn't it true that the approach of the company to this particular site with respect to whatever is in the ground and the groundwater will be taken care of by the company paving the area where the BSS is to be located?
I would not say that that is true.
Well, what would you, will it be fair to say that the company intends to excavate significant amount of soil and perhaps contaminated groundwater, remove contaminated groundwater from the project site?
As recommended by our licensed site professional, the company will be looking to do a limited site investigation on the property at a later date.
Doesn't answer my question. Isn't it fair to say that the company will handle the issue of potential ground and groundwater contamination by paving over the area where they're going to put the BESS facility?
If, as I've previously testified, if there is any sort of identification of wrecks on this subject parcel, we will of course ensure that we comply with all reporting and remediation requirements associated with that finding.
Does the company intend to pave the area over the BESS, the prospective BESS site?
It does not.
Does not?
No, it does not.
How are you going to, what will be the staging material for these 20-ton BESS units?
As shown in our site plan, we proposed the area to be a gravel base.
All right.
With concrete pillars or pads or supports, potentially. Pending further geotechnical investigations at a later date.
All right. If I might, Mr. Keller, if I could just go off the record for a minute with my co-counsel, and then I probably can finish up.
Certainly.
Let's see.
Mr. Rice, you need to mute.
I'm going to mute. Well, I think
Are we off the record?
Yeah, we are, but
I'm not talking. I'm asking.
We're off the record.
Oh, all right, back on the record?
Great. Do you have additional questions, Mr. Reich?
I don't have additional questions. I would,
We're not on the record right now.
oh, I thought
Okay.
we were.
No, we didn't go on the record.
Sorry. On the record. Mr. Reich, do you have
Okay.
additional questions?
It's not a question, it's another renewed request. That is, that until we see till we see the land control agreement from 22 and the amended land control agreement from 24, I really can't conclude my questioning of Mr. Benito. And as we said, and as Mr. Ferry said, we respectfully don't need to see the cost information that could be provided in some way to Mr. Pucci if he wants it. And I understand he has a different view, but we just simply want to see the site control documents because they speak very directly to all the questions that I was asking of Mr. Benito. They speak to the questions Mr. Ferry was asking about noise and so forth, and for all the other reasons that we've explained. So with that comment and with that reservation, I've concluded my questioning for today.
Right. Is it fair to say that you've asked all the questions that you intend to ask, other than those questions that you could ask with the benefit of seeing the documents that you referenced?
That's fair to say, unless they pop another document into the record during the third and fourth week of this hearing. But yes, other than that, yes, of course.
That's kind of unfair, Mr. Reich. It turns out that it does turn out that the document was in there and that you just didn't see it. So let's not blame the company.
I never saw the GEI document, and that wasn't produced until Monday. So let's not try to quibble. Let's just go on. Thank you.
I'm wondering whether people are able to stay beyond 5 o'clock today, because I think it could be advantageous to allow us time to ask the questions we need to ask today if we stay beyond 5 o'clock. So let me just go around the room and start with the company. Are you able to stay beyond 5 o'clock?
Yes.
Fair to say you could stay till 6?
Yes.
Mr. Pucci, are you able to stay until 6 o'clock?
I am. I would just note that accommodation that I had requested earlier before we went on the record about Friday, but I just wanted to remind you of that. But yes, I can stay till 6, no problem.
Okay, and I will address that actually in just a moment. Mr. Reich, are you able to stay until 6 today?
Of course, yes.
Mr. Ferry?
I can, yes.
And if the Salpes are present, are they able to stay until 6? All right, I believe they are not present. Mr. Pucci?
May I break in for a minute?
Yes, you may.
I'm
sorry.
I'm happy to stay until 6 or whenever, if we could just take another break before then.
We certainly would, and thank you. And I apologize for not having asked you, but Mr. Pucci, we did confer among ourselves in an effort to accommodate your request about Friday, and we up here are able to. We would be able to meet tomorrow, but that doesn't work for the stenographers. So it's a no-go to do it tomorrow. We didn't even ask the other parties. And it is important that we finish this hearing sooner rather than later. So I'm not going to be able to accommodate your request, Mr. Pucci, for Friday.
Okay, thank you. Thank you for considering it. I have a serious issue to raise that I want to raise on the record before you ask your questions.
Now would be a good time.
I mean, I'm surprised that I'm noting this because the witness just testified under oath, but I did a quick comparison of the table 6-2s the latest fully unredacted version that didn't have the identifying information from the report. And then I took a quick look and compared it to the company's counsel just emailed out during that session the document that I had requested, which was apparently produced to the siting board before, unbeknownst to me. And it purported to be the original redacted document in the report, but unredacted. And I very clearly asked the witness under oath earlier if there was anything different about that document than the footnotes. And he confirmed that there was not. And then I did a quick comparison. And there were several numbers that are different. And I'm not saying that they're dramatically different, like 100 versus an 80. But for instance, in the first column for Tesla Megapack, the earlier document that was produced by email today to me for the first time says 84 under the octave band reporting, and the one that they produced when they produced an purportedly unredacted copy a couple of weeks ago has 82.7, 82.7 for both of those numbers. I'm picking those two out specifically because that's not a rounding thing. In other words, if it said 82.7 now, well, I can't address it at all because it's clearly not a rounding thing. And if anything, it would have been rounded down from the original document. So I have a serious concern about this. And I'm going to, again, I'm looking at it for the first time in real time. And I'm doing my best to compare it. But when I do a quick comparison, it is in fact not exactly the same information as the earlier report that the witness claimed it was. And he asked, when I asked him the basis for all that, how we could tell, he basically said, well, take my word for it under oath. So I guess I'm renewing my motion to strike the Epsilon Sound report as well as the witness's testimony. Because this actually, based on his testimony just now, and again, it's not a matter of a number between 100 and 80. Discrepancies look like 82.7 versus 84. But the fact is, it shows absolutely the purportedly fully unredacted document, which was supposed to be the same document that was in the original January 2026 report, is in fact a different document. And I just asked him about it. And this is outrageous. It constitutes a fraud on this board, and I renew my motion.
Thank you, Mr. Pucci. So I think there are two ways that we can handle this. One would be to hear from counsel for the company, or you could continue cross-examination, Mr. Pucci, of the company's witness to gather more information about the discrepancies that you have noted.
I'll stick to the testimony under oath on the record, and I'll raise this in my post-hearing briefing. And if you don't want to, if my motion to strike is denied, I'm going to raise it in the post-hearing briefing, because this is actually absolutely fraudulent, and I'm not going to go stumbling around on it in real time when it's very clear that the document that was contained in the original report is not the document that was produced in subsequent unredacted format. Nor is it necessarily the document which was produced to your board, because I've just found a discrepancy in the document that was produced to your board, unbeknownst to me, and then the document that was produced to your board and everybody on the service list. Those are different documents. So not only am I misled about what the witness just said, but the board is as well. There's no way for the board to confirm that what they produced to the board was the document that was in the original report.
So
And
I
I've
understand.
spoken enough on it. I've made my point on the record, and that's all I have to say about it.
And I've understood you to say that you do not wish to conduct additional cross-examination today. I would like the counsel for the company to have an opportunity to respond to the concerns raised by Mr. Pucci, please.
We can have Mr. Callahan explain. I can do that on redirect, or you can just ask him.
I think based on what I just heard, best for you to do that on redirect. And
Okay.
I'd be inclined to have the redirect happen right now.
Okay.
Does that make sense?
So Mr. Callahan, you've heard what Mr. Pucci said. Can you provide an explanation?
Sure. So there were two initial reports prepared. There was the redacted version and the confidential version, or the unredacted version. And those had, the only difference was table 6.2, which was blacked out and redacted. When we take that black redaction off, that is then what was presented in those two versions, and there was no difference between those two tables. Subsequently, at the request of the peer reviewer, I believe Mr. Nitchin, we provided a third version of that table that had more detail in it, in an effort to help him be able to use that for his modeling. So we added additional details out to the 10th place, and we also provided additional footnotes indicating where uncertainty was added into our modeling. The difference, the discrepancy of the numbers is because the Tesla data comes to us in a 1/3 octave band format. So essentially there's more numbers than what our table is reduced to, but the numbers in our table are what is needed to do acoustic modeling, because the acoustic modeling is done based on whole octaves and the pure tone analysis is done on whole octaves. So when you type in that value into our model, it gives us numbers, and that's what was put out in the initial version. But because we wanted to be helpful to Mr. Nitchin to do his report, we provided more detail that representative of the numbers right off of the Tesla data set.
Does that conclude the redirect?
No. Does do any of those numbers or change in the numbers change your opinion on the model itself or the noise assessment for this project?
No, if either of those numbers as presented were plugged in, all of the results would be the same as what our report currently shows. The conclusions of our report would be the same.
Thank you. I have no further questions.
And Mr. Pucci, I just want to give you another opportunity in case you have any additional questions.
First of all, the information wasn't produced at the request of Mr. Nitchkin. Okay, I raised this as a motion to compel, and then the documents were presented out in a drip fashion, purposely, so that they were produced during the hearing, so that now I would have less of a time to prepare and consult with my own expert. So they ended up producing these reports pursuant to a motion to compel, not by any request from Mr. Nitchkin. That had nothing to do with it. I moved to compel, and so they ended up producing them. Today, he admitted under oath that the first time that they did it in partially redacted format was a mistake, even though Attorney Kaplan stuck to that mistake and that they were well within their rights to redact that information. The witness said today it was a mistake. Then they said, I still don't understand the answer why they were miraculously able to produce the Tesla information unredacted and they couldn't do it before. I didn't really understand the answer to that question, but I moved on. I'll note too on these reports, that answer is nonsensical and it's not responsive. There are two numbers on here, 82.7 versus 84. In no universe of math does the number 82.7 round up to the number 84? And again, it raises an issue about the reliability of these reports and what was the data reported in the initial report. So I'm going to renew my motion to strike. His earlier testimony under oath will stand on the transcript. And once I digest all this information, I'll raise it in post-hearing briefing. He testified under oath. One last thing. Earlier, he testified under oath very clearly. There was nothing different from the table that was attached to the original January 2026 report, other than the footnotes that I went through with him in painstaking detail. Every other number, he said, was exactly the same on the original redacted table and the ultimately unredacted version that was produced by Attorney Kaplan prior to today, pursuant to my motion to compel. So that testimony was not correct, and it was just 2 hours ago under oath. So the record will stand as it is. The witness clearly said there was nothing different in the report other than the footnote information. The report, my final statement is, this report should be stricken from the evidence. This is outrageous behavior. It should be sanctioned, and the report should be stricken from the evidence. Thank you.
All right. So I understand that you are renewing your motion to strike, Mr. Pucci, and I will review later whether I will require you to put anything in writing or whether your initial motion to strike will suffice. If I could ask the witness a question. An assertion was made that you stated that the numbers in the report were the same in the unredacted version of the initial report as the report that was as the second version of the report that was produced a week or two ago. Would you please comment on that?
Sure. So what I mean, there's no difference. When we initially produced the report, we had two versions. We had the redacted and the unredacted version. And the only thing we did was cover the table with black to not show the sensitive sound level data because we were under an NDA. So those two tables were identical. That's what I was referring to about being the same. We then produced another table in response that I was under the opinion was going to a peer reviewer to be used for acoustic modeling. So I provided more detail in that table when we provided it for the third version, I will call it. And that's why there are differences in those numbers.
Okay, so you're acknowledging that there are differences in the numbers between the version of the report that was produced today, correct? And
So
the version that was produced a week or two ago, correct?
Right, there was a change to the table that was in response to the request to receive additional information, and there are differences in those two numbers. That's correct.
And is that different from your testimony earlier today?
Well, earlier today, I was saying that there's no difference between the redacted and unredacted version of the original report because those tables were unchanged. So if we're talking about the original unredacted table and the more recently prepared table, then they do present slightly different values because of how we pulled them out to portray to the peer reviewer. Yes.
Okay. Mr. Chang, do you have additional questions?
Yeah, yes, thank you, hearing officer. Directed to Mr. Callahan. So how do you explain the seemingly non-rounding errors and the lower octave band, specifically the 31.5, 63, and 125 hertz ranges compared to the rest that appear to be more of a rounding error?
So the manufacturer only provides data down to about 125 hertz. So those lowest 2 octave bands, we have to assume those values, which is denoted on one of our footnotes. The difference is when we type these values into our acoustic model, we are using 1/3 octave bands. So each one of these numbers is actually made up of 3 different numbers, and the model adds them together to come up with a value. So in the initial report, we transcribed it out of our model, basically copy and pasted it right out of our model into this table. In the newer version that shows the 10th place precision, we use the Tesla data and just carried that through, and that's why they are slightly different.
And go ahead.
Either value that you would type in would give the same results and conclusions of our study.
So to follow up on that, so even though in the updated table 6-2, we're seeing different values, but once you plug into the model, it pretty much becomes what the original table display. Am I interpreting your response correctly?
That is correct. There's the model adds these sound levels together, and then you can ask the model to give you these values, or you can just take it right out of the document. And we did it 2 different ways, unfortunately, and that's why there was a difference. I was trying to be as specific as possible when we were providing it to the peer reviewer so that they could model exactly what we typed into our model.
Okay. So while the layman's might recognize them as different, would you, in your opinion, expect Mr. Nitchin to see these as the same, given that of his familiarity with the noise model?
I would expect he would see them as a negligible difference.
Thank you. That's all my questions.
I have some follow-up on that, Mr. Hearing Officer.
Go ahead.
So I'm just, first of all, I didn't ask you if the results would be the same earlier, sir. I asked you whether there were any different numbers in the original redacted version to the version that you ultimately produced through council a couple of weeks ago. You said there weren't any. You didn't tell me anything about some of the numbers were slightly different, but it came out to the same result or anything like that. And we went through it in painstaking detail, and I identified everything that was different, and you identified it under oath, okay? So let me ask you just about a couple that Mr. Chang just asked about. If I just take these 2 numbers here, I'm looking at the first column with Tesla Megapack. The version produced by your council today, that was purportedly the version that was in the original report from January of 2026. 2 number columns over under sound level per unit dB by octave band. The first 2 numbers are 84 and 84. Okay. When I go back to the one then 6-2 that your council produced a couple of weeks ago, those 2 numbers are 82.7 and 82.7. That's not a difference of a rounding error, because that's 1.3 digits off, okay? So why don't you explain to me how in the world you're trying to claim that changing the number from 84 to 82.7 was purportedly to provide more detailed information to our peer reviewer? What does that have to do with it?
Again, it's to go back to the first part of your question. When we were going through the redacted versus unredacted, those 2 tables are identical in the original set of reports. The table that now has the 10th place precision has different values, and that is due to how the model calculates those octave bands, because we have to type in all of the 1/3 octave bands that Tesla gives us, and then we have to assume octave bands for those lower values. So when we copy and pasted out of our model in the original version, that was 84. But if we copy and paste using the 10th place precision from the Tesla data, and we take away the uncertainty of 1.2 that's in the footnote, you have a different value there. So that's the Tesla, that is the Tesla value in that table.
Do you feel the need to correct your earlier testimony that was made under oath that's reflected on the transcript, or that's going to be reflected on the transcript that gets produced tomorrow? In response to my earlier questions before lunch?
I think I already did in response to the EFSB's question, and then just to you.
Well, when you see that testimony reflected of yourself in response to my questions, as you remember them sitting there, do you feel the need to correct that testimony that you made under oath?
I think it's just been corrected.
Okay, thanks.
All right, we will continue with questioning from Mr. Chang.
Thank you, hearing officer. I have questions directed to the panel, and I'm going to ask question on a few topics. The first one being solid waste and hazardous materials. First question, refer to exhibit MS-1 at page 26 to 27, which is the company's petition and analysis.
I'm sorry, Mr. Chang, can you repeat that? MS1 at?
26 and 27.
I see it.
Okay. At the beginning of section E, reads all waste generated during demolition, site preparation, construction, and operation.
I'm sorry. All waste generated during.
I'll speak lower, Alan. All waste generated during demolition, site preparation, construction, and operation of the project will be transported off-site in accordance with local, state, and federal guidelines and regulations. End quote. And the passage goes on to describe how the company would handle and dispose of non-hazardous and hazardous waste. My question is, does all waste generated includes the large debris related to the former automobile salvage operations, such as car frames, car parts, car tires, and metal drums? I'll refer hereafter as the large debris.
I'm sorry. I may have missed the question there. The large debris what?
So does the large debris, including the things that I just mentioned, encompass the phrase all waste generated as described in page 26?
Yes, it does. I would direct you down to later in the paragraph where it says that this is the historical usage as an auto salvage junkyard, where we would anticipate that solid waste being managed in accordance with the local, state, and federal guidelines. Yes, sir.
Thank you. So, and just to get a little bit more specific, so does this all waste generated refer to the debris across the entire project parcel or only a specific part of the parcel?
Yes, that specific line is referring to the limit of work as proposed in this hearing. So not the entire parcel, but the parcel where we've requested permission to construct the project on.
Thank you for the clarification. And to get just a little bit more specific, so is the company proposing to clean up all the large debris present in the construction limit of work, or only the large debris that is disturbed during the project construction?
Okay, that's a good question. So I would say that, you know, the project footprint in the areas that we have requested to actually disturb, that disturbed area would then, in the process of the construction activities, would then generate this waste, as you referred to as large debris. And as such, we would then be required to and obligated to go ahead and handle and dispose of that waste.
So that would not include large debris that is within the limit of work, but is otherwise not disturbed by the construction. Is that correct?
It is our anticipation that the majority of the area within the limit of work will be disturbed in one manner or another, whether it's for staging equipment, vehicles, sedimentation, erosion controls, etc. So that would be our anticipation, that the area within the limit of work would therefore be generating this waste.
Okay. So is it, I hear what you're saying, but does the company anticipate to clean up all the large debris that is within the limit of work, or there is a condition that they are disturbed?
No, sir. It would be all of the area within the limit of work.
Okay, thank you. I wanted to turn next to record request INT-1, and we'll go to page 3 once you're at it.
One moment, sir. Sorry, we don't have the record requests. We're getting them.
Okay.
Could you repeat the record request?
It's a record request INT-1, page 3. Oh, I'm sorry. Yeah, it should be the attachment to that record request. Wait. Never mind. Yeah, I believe it's the redacted
Yes.
document. Yes.
Yes, sir. We have it.
Great. Can you provide the definition of recognized environmental conditions, short for REC?
I'm going to defer to Mr. Bergeron on this one.
Sure, again, I'm not an LSP, but my understanding of a recognized environmental condition would be during a due diligence or a limited site investigation. That's the term that it's associated with that type of investigation. And so what that would be is a number of different things potentially on a project site when a licensed site professional is looking at a site. So it would be a known release or a cleanup action on that site that's documented through Mass DEP's Bureau of Waste Site Cleanup. It would be visual observation of activities on a project site. As part of a limited site investigation, there are also interviews completed based upon owners of the site, occupants of the site that have been using that for land uses. So understanding what historically a site has been used for and how it's been used also could raise a potential recognized environmental concern. And also being on site and looking at things such as, drums or car parts that still have like physical observations, sheens, things that you can see that are recognized. I mean, even just, again, those features being there themselves represent a recognized environmental concern as identified in the limited site investigation that's on record that was completed by SWCA. but also observations of the sheen, and also if there's any sampling done as part of that, and there are either groundwater samples or soil samples that come back with over-reportable concentrations, obviously that would be a recognized environmental concern. So those are the types of things in a limited site suitability, which is also called a phase 1, that would rise to the category of recognized environmental concern.
Thank you. Is there any difference between a potential reg versus an identified reg?
Yes. A potential rec, again, is just in the limited site investigation of the potential. And then you would do additional investigations to identify if it is the confirmed potential actually exists. Right. So you're going from here's the potential, here are the things that we see, I guess, indicators, to actual doing soil samples, doing sampling and looking at it and identifying that, yes, something specifically exists there.
I see.
And then I'm sorry, and then an identified environmental concern would then raise to a level of, if it exceeded reportable concentration and reportable limits as part of the 21E program, there would be time limits on reporting requirements, right? So a licensed site professional, and that those, when they undertake these investigations, if they do identify environmental concerns that exceed reportable limits on the state list, they're obligated to report that within a certain time period to Mass DEP, and then get into the Bureau of Waste Site Cleanup 21E program.
Thank you. And to follow up on that, so what does it take between between a potential REC to become an identified REC? You mentioned a little bit about sampling, etc. And I'm asking kind of just high level, what type of process does it take, like such as maybe the phase 2 ESA or etc.
That's exactly what it would take. It would take what would be characterized as phase 2 investigations, or even in some instances, the limited site investigations completed as part of a phase 1. If they come back with reportable concentrations, then that then kicks them into the obligation to get into the 21E program as an identified environmental concern.
I see. Thank you. So does the identification of a REC automatically imply there is an environmental impact at the location?
Sorry. So does the identification of the
REC, the REC, automatically imply that there is an environmental impact at the location of identification?
No, it only implies the potential, and the potential that there's a risk, and that it warrants additional investigations in a licensed site professional's opinion. I
see. So, and going with that, now generally, what legal responsibilities are associated with RECs identified with evidence of environmental impacts, and how are they treated in the Massachusetts contingency plan?
Within that program, if there is an identified environmental concern that exceeds reportable limits, there's an obligation for that party to get into that Mass DEP 21E process and report it within a 120-day period. And then there are continuing obligations to do additional testing, reporting, and develop remedial actions with Mass DEP as warranted. But the initial trigger of there is a reportable environmental concern or something that's identified through sampling to exceed reportable limits, there's a 120-day obligation to report that to Massachusetts Department of Environmental Protection.
Thank you. And to whom would those responsibility lies? Like
Yes, I do understand your question. That the potentially responsible party would be the landowner.
Okay, thank you. Thank you very much for the explanation, Mr. Bergeron. I would like to follow up a little bit on something that I believe Mr. Benito answered on day 2 of the hearing, but we'll stick to the record request that we have in front of us, but also to the transcript number 2 at page 354. I think it will be helpful if Mr. Benito have that in front of him so that we can go over something to get the clarification.
We are on page 354.
Okay, thank you. We'll get to there just in a moment. I just want to go over something that's on page 3 of the record request. So the author of the review, GI consultant, reported that
I'm sorry. So the what?
the author of the review, GI consultant, reported that, quote, based on the results of the limited site investigation, it was SWCA's opinion that no evidence of environmental impacts from the identified RECs were documented for the subject property. SWCA did recommend that the above-ground oil tanks and drums/containers containing petroleum products and waste vehicle fluids observed in the garage along the north
Forgive me. I'm sorry, Caleb. Containing petroleum products and waste.
vehicle fluids observed in the garage along the northwest exterior wall of the garage and in the truck scale shed be removed and properly disposed of according to applicable local, state, and federal regulations, end quote.
I see that.
Yep. Are the above ground oil tanks and drums/containers in and around the garage what, Mr. Benito, you were referring to on day 2 of the hearing, page 354, quote, a few things like drums and containers to be removed from the site, end quote?
Yes, sir.
Okay. So does what SWCA was referring to include any part of the large debris we discussed in the last set of questions? The
No,
previous
sir.
question.
No, sir.
Thank you. Yeah, I just want that clarification. Thank you very much. I'll next move to my next question, and this is also in consideration of the rest of this record request that was discussed in the cross-examination of your panel by Mr. Reich just earlier in the hearing today. So considering the phase 1 ESA and limited site investigation done by SWCA, the environmental due diligence review done by GI consultants, and the subsequent site visit, which is done by Epsilon with the GI consultants representatives present. Is the company aware of any other records or documents that have to identify additional RECs on the property, on the project property?
No, sir.
So would it be correct to say that except for the above ground oil tanks and drum/containers in and around the garage, the document I referenced did not identify any part of the large debris across the project parcel, including those found on the northern property boundary, as RECs?
That is correct.
Thank you. Now turn next to day 3 transcript. So transcript number 3 at page 542.
Okay, we're here.
Okay. In response to Attorney Pucci's question about any environmental violations discovered, Mr. Bergeron identified quote, remnant automobiles, parts, and chassis within wetland resources areas, end quote. Particularly within the bordering vegetated wetland and the southeastern portion of the project property. Please explain how such, quote, remnant automobile parts and chassis within the wetland resources areas, end quote, constitute environmental violations, including referencing the relevant statutes and regulations, please.
Sure, I could speak to that. I mean, again, when we delineate wetlands or assess sites for the presence of wetlands in Massachusetts, it's not uncommon to see previously disturbed sites have features such as this or other features where, you know, the prior landowner, and maybe even, you know, the landowner before the current landowner, may have done some things without permits. Again, I don't know the permitting history of this site, but assuming that the auto salvage yard operator did not have a permit to push earth and put auto parts into that bordering vegetated wetland, that would constitute a violation. It would be an alteration, unauthorized alteration, if there was no permit for that under the Massachusetts Wetlands Protection Act. Also, depending upon the size of the violation, the 401 water quality regulations, and again, depending upon the classification of that area and its presence within the Ware River watershed, it may also constitute a violation of the Watershed Protection Act.
Thank you. Now, do these statutes and regulations require any remedial actions?
They don't specifically up until there's an enforcement order issued either by the state or the local conservation commission on the current landowner. And then that enforcement action, depending upon the severity of it and the conservation commission's desire to work through that enforcement action, would and could involve remedial actions to remove the violation, the unauthorized activity, and file subsequent permits to do so.
This is Mr. Vito from the company. I would like to, with regard to the car that we're talking about here in the southeast corner BVW, I would like to highlight the fact that this car is very, very old. It was just a chassis left there, no visible oil or anything like that. And it is not the company's position or Mr. Bergeron's that was a wetland when that was put in or placed there. That would be outside the scope of Epsilon and frankly would be predating any of our awareness of what that actual wetland may or may not have been at that time of that action.
Thank you, Mr. Benito. That said, I think that adds to whether the company have foreknowledge of that situation. But given what is there right now, would the company be responsible for the remedial actions related to such environmental violations?
But it would be something that would be certainly reviewed through the Wetland Protection Act, with the Conservation Commission and or Mass DEP. I'm not in a position without having the specific investigation of that particular vehicle we're speaking of. I don't have enough background as to the history of it or if there was any violations made. That being said, of course, if that is to be something that was to be needed to be remediated through that subsequent permitting, we would, of course, comply with the law.
Thank you. I'll next move to different sets of exhibit, but also will involve day 3 of the transcript. So given that you might be on a transcript, I want to turn to page 565, and I'll make reference page 565 through 568, and then 576 through 579 on the transcript. And I would also like to refer to exhibit EFSB-LU-2.
Yes. Thank you. I have it.
Great. So I understand that the company has stated that it has no plan to clean up the remainder of the parcel. I wish to explore the option that the company remove all large debris within the parcel as part of this project. You may respond verbally or take this as a record request, and I'll read it and you can decide. Discuss the feasibility of the removal of all large debris related to the former automobile salvage operation, such as car frames, car parts, car tires, and metal drums across the entire project parcel. The response should address, number 1, technical feasibility, number 2, scheduling and logistical feasibility in the context of the project construction, number 3, cost and financial feasibility, number 4, legal concerns, if any, and number 5, consistency with state policy.
Can you just give us one moment, please?
Certainly.
Okay. Yeah, I would appreciate if I could take that as a record request so that I can ensure.
Sorry, I would appreciate it.
If I could take that as a record request so I can ensure I'm adequately answering all of those bullets.
Thank you. I'd like to ask the hearing officer.
Sure. So that'll be record request RR-EFSB-10, excuse me, -11. And I think that'll be a good time for us to take a break.
Certainly.
So let's report back at 4:45.
Yeah. Mr. Presiding Officer, you think we'll be getting to Mr. Anderson today?
Yes, I do.
Okay, thank you.
Thank you. Off the record. with you. If you could unmute me, I will check in with folks.
Unmute.
All right, I see our stenographer is at the ready. Looks like Mr. Ferry's there. Mr. Pucci's present. Company panel mostly is present. Do we need to wait for anyone, Mr. Kaplan?
We do not.
And Mr. Reich, are you present?
I am present. Thank you.
All right. We'll go back on the record, please. Mr. Chang, if you would continue.
Thank you, hearing officer. The next I will ask two questions on several questions on general topic and land use. Please refer.
I'm sorry, general topic what?
Oh, on land use. On land use.
Land use?
Land use.
Land use.
Oh, land use. Thank you.
Thanks, Alan. Refer to Exhibit OAK-20, parentheses 1.
Wait.
You got it?
2021.
OAK-20, attachment 1.
Yes,
Does the company plan to purchase the property?
yes,
Does the company plan to purchase the entire property or only a portion of it?
the entire property.
Thank you. Next, I will refer to Exhibit EFSB-LU-2, EFSB-Z, as in zebra, -1, and OAK-22.
Okay,
The company stated that it does not have a plan to expand the project after construction, develop large-scale solar on the property, nor develop the rest of the property. My questions are, does the company anticipate any additional commercial or industrial uses unrelated to the operation of the BESS facility for the existing improvements, namely the garage building and the surrounding parking areas?
I'm sorry, just one more clarification. The company does not anticipate any other commercial activities happening on the property in addition to or alongside the proposed project. Was that your question, sir?
Yes.
Correct. The company does not have or anticipate any plans to have additional commercial operations or industrial operations on the site.
Thank you. Now, your response notwithstanding, how feasible would such additional use be?
I would have suspect it would be very low feasibility given the constraints associated with the resources on the site. The way that the company has proposed this project, we have essentially taken up all the allocated land that does not have jurisdictional resources on it.
Okay, thank you. What is the feasibility of using the rest of the project parcel for agricultural purposes?
I suspect there could be agricultural on the rest of the project. I'm not familiar with what products or crops would be suitable for that land area, but I don't have any plans for doing agriculture there, but I suspect that there could be farming in that area if that was something that needed to happen, but that is not a plan of ours at all.
Thank you. And let me clarify too. And I asked the previous two questions in the context of the best being there. So does that change your answer?
No, sir, the best being on the project site, and it's our position that that would take up all of the available land that would be suitable for development.
Okay. I'm going to ask about residential uses as well. How feasible would that be on the rest of the property?
I don't believe it would be feasible at all.
And does the company anticipate any subdivision of the project parcel?
No, sir.
Thank you. I will jump to the traffic topic next and finally get to Mr. Anderson. Thank you for sitting in the meeting through the earlier cross-examination. And I'll ask you several questions here. Refer to exhibit. Oh, actually, it's not exhibit. It's the record request EFSB-4, attachment 1, which is the sweep path analysis.
We're gonna print it real quick.
Okay.
I am familiar with it if you'd like to ask a question while we're retrieving the printed copy.
Oh, sure. Oh. And if you oh,
sorry, go ahead. Sorry.
Okay. Yeah, if you have to refer to it later on, then feel free to wait. So page 4.
Mr. Chang and Mr. Presiding Officer, this is Attorney Pucci. I just wanted to clarify: are we moving on to another topic, or?
Yes, we are.
Yeah. I just had a couple of follow-up on Mr. Chang's questions that went to the environmental cleanup issue. Do you want me to wait, or?
Mr. Chang, what do you think?
I think it'll be easier if you can wait and yeah,
Perfectly happy to wait. Just wanted to clarify. Thank you.
Thank you.
Appreciate it, Mr. Pucci.
So I do have the record request previously referenced available.
Okay. Page 4 of this analysis shows an encroachment highlighted in red for a WB67 interstate semi-trailer going north on Colebrook Road to turn into the property.
Correct, I see that.
Okay. What is the company proposing to address or resolve this situation?
So the analysis referenced here is a WB67 tractor trailer vehicle, and it indicates that a vehicle approaching the site from the south on Colebrook would encroach on the abutting property. Just a moment. The previous page, page 3, indicates a WB67 approaching from the north, and there are no encroachments on abutting properties from the north. I'll bring attention to our response to EFSB-T-8, and where we note in Part B that we are anticipating routing construction traffic from the north. And again, as indicated on page 3, that maneuver is possible without any encroachments on abutting private property.
Thank you. So the solution will be to limit any construction vehicles or related traffic involving a WB67 limited to the coming from the north of the north from the north. Is that do I interpret that interpret
That's correct. Yes, sir.
Correctly. Thank you.
Mr. Keller?
Yes, Mr. Reich.
Is it possible to have the swept drawings that are being referred to, put on the screen since they were not put up at the last hearing because they had not yet been entered into the record.
Sure, we could do that.
Give me 1 second. So for the benefit of Mr. Reich, I just want to point out that the screen is showing where the red area highlight is regarding the encroachment onto the abutting property. And I believe Mr. Anderson point out that if the truck come from the north, then there will be no encroachment. And that will be the solution the company is proposing.
And just going back to the prior diagram. Can Mr. Anderson just identify which abutting property he's talking about?
You have the text of the IR, it's 360 Colebrook. The question for EFSB 4 references the number, I think it's 360, but I want to be accurate. Just a moment, please.
Sure.
EFSB 4, it's 125-1.
If I can clarify, is it property 360 Colebrook Road?
Yes.
Yes, sir.
Yes, it is 360 Colebrook Road.
All right, just for the record, that's a Stevens's property, correct?
Correct.
Thank you.
Just 1 moment, please.
Yeah,
Thank you.
Mr. Reich, are you good? Oh, I will continue then. Does the sweep path analysis, so for the WB67, for all of the scenarios, including this one, accounted for the elevated road embankments and stone walls, as well as tall trees along Colebrook Road near the entrance to the project parcel, as identified by Mr. Stevens on day 5 of the hearing?
Yes, it does.
So I am interpreting this to say that those elements will not impede the turning movement here, as shown in the sweep path analysis. Is that correct?
That is correct. The features noted that you've mentioned, adjacent steep embankments, trees, walls, in the vicinity of the entrance are all located outside of the paved roadway. The survey that we use for this analysis indicates the extent of the paved roadway, and the vehicle is able to stay within the extents of the paved roadway. So any of those features located outside of the paved roadway are not consequential in terms of the vehicle's ability to make this maneuver.
Thank you. And to verify, beyond the WB67 movement, would the embankments, stone walls, trees impede any other construction, delivery, and emergency vehicle movements?
No, not to my knowledge. We've used the WB67 as the delivery vehicle for this analysis, and none of those features you've mentioned impact its ability to deliver components to the site.
Thank you. With that said, does the company anticipate any need to make alterations on properties beyond the project parcel, such as cutting trees, modifying stone walls, excavating and filling, expanding pavement areas, and etc.?
No, sir.
Thank you. And is the sweep path analysis based on single point turns? And to add to that, does the company anticipate any construction, delivery, and emergency vehicles would need to make multi-point turns to navigate the turn between Colebrook Road and the access drive?
No, they're not anticipated to require multi-point turns. This analysis indicates a single point turn to enter the driveway. So put another way, we expect they'd be able to just enter into the driveway without 3-point turns or any other maneuvers there.
Thank you.
To clarify, coming from the north.
Okay. And with this sweep path analysis and your understanding of the project so far, would the traffic impede any installation of, let me clarify, would the construction traffic impedes any installation of storm, water, and erosion control infrastructure or devices, such as straw bales and other controls?
No, we would not anticipate the delivery vehicles impeding the ability to install erosion control devices that are standard for these types of maneuvers. We would anticipate that during construction, those erosion and sediment control systems will be added and in place throughout the duration of those processes.
Thank you. Now, if you look at the screen, which is on record request -EFSB-4, parentheses 1, I would like to get your attention to the bottom of the V on the SX drive. If I can zoom in a little bit more and more. And I noticed that there's a small part of the access drive appeared to encroach onto Mr. Stevens' property. The same encroachment is shown on other pages of the analysis, as well as on the revised site plan for the project, Exhibit MS-A, Supplement 1. Is the company aware of this situation?
Yes, the company has noticed that the existing driveway does appear to leave the corridor there.
So please elaborate on the implication on this project.
This driveway was previously developed, it's existing driveway. So from our perspective, we didn't propose to make any improvements or construct any sort of additional features that would have further impeded or gone beyond what is already currently there.
And if I may add, as shown on the screen here, the existing pavement line appears, as shown here and from our survey, to overlap the boundary of the property line. However, the WB67 delivery vehicle turning movements stay within the property boundary. So that portion of existing driveway is not necessary for that vehicle to make this maneuver shown on the screen.
Thank you. And it's based on, I can move around and on the screen, but based on what you know on the sweep path analysis, that's the same for all the other scenarios, that it can turn without encroaching onto the abutting property?
That's correct.
Thank you. And to follow up on my previous question regarding erosion control, will this impede any erosion control that the company is going to implement as part of the project construction?
No, the company anticipates installing erosion control in areas where there's earth disturbance in accordance with the stormwater pollution prevention plan.
Thank you. Now I'm going to stop sharing on this and move on to another exhibit. Please refer to exhibit. Oh, actually, again, it's a record request dash EFSB dash 5.
Yes, we see it.
How long does the company anticipate peak construction to last?
Company is currently anticipating construction to last approximately 12 to 16 months.
So in the context of the record request, that will mean the traffic level anticipated for the peak construction will occur during that 12 to 16 months.
I would say that peak construction in the context of this record response pertains to multiple phases overlapping. So for example, the site clearing and grading overlapping with the tree clearing activities, or deliveries of the batteries overlapping with the other aspects or phases of construction. That is what I was intending to portray when I said peak construction, the overlap of various phases of construction. That answers your question.
So for overlapping, do you mean the highest level of traffic as described will occur during those overlap, but those overlap does not happen constantly during that 12 to 16 month period?
Yes, sir. That's what I was attempting to portray in this response.
Okay, thank you. I have finished all my question. I believe my colleague, Ms. Lowe, have questions for the panel.
This is just a quick clarification question. In my review of the record, I noticed the acronym AIS is used twice to refer to different things in relation to the interconnection facilities. In exhibit MS-1 at page 11, it's used to refer to an air insulated substation. And then in EFSB-D-9, the same acronym is used to refer to an air insulated switching station. So I would just like your clarification on which is the appropriate term to describe the equipment referenced.
It would be the substation.
Okay, thank you. That's all for me.
Mr. Pucci.
Yes, I just had a few questions for Mr. Benito in follow-up to some of what Mr. Chang asked.
Hold on, Mr. Pucci. I did have some follow-up questions for the transportation expert. I'm happy to take them after you take these questions to Mr. Benito, but I do want to make sure I get them in while Mr. Anderson is here.
Understood.
Can I just ask if we need Mr. Bergeron anymore? We're trying to salvage his marriage.
So you're asking questions for Mr. Bergeron first? Is that what you're asking?
No, I'm asking if anybody has any questions for him. Otherwise, I'm going to see if he can head out for the day.
Mr. Pucci.
Mr. Pucci, do you have any questions for Mr. Bergeron?
I didn't, although he might want to weigh in on ask Mr. Benito. I mean, I have like a minute of questions, so I don't think it'll jeopardize his marriage.
All right, why don't you go ahead and ask your questions, Mr. Pucci?
Great. Mr. Benito, in response to Mr. Chang's questions, you testified that any current wetlands violations, such as car parts in wetland areas, would be the responsibility of the enforcement authority, such as the Conservation Commission, to investigate and issue an order to clean it up. Is that right?
Yes.
Do you agree today to schedule a site visit for the commission to come and investigate this issue before deciding whether to issue an enforcement order?
Yes.
Who should the commission contact in order to schedule that?
Me.
Excellent. Thank you. Those are all the questions I have.
Mr. Reich, do you have any questions for Mr. Bergeron?
No, I do not.
All right.
Thank
Do
you,
the
Mr. Presiding
Salpes have any
Officer,
questions for Mr.
Council.
Bergeron? Okay, hearing none. Yeah, Mr. Bergeron, thank you.
Thank
Bye-bye.
you, greatly appreciate it.
No, well, so Mr. Reich, I believe you may have additional questions. Is that right?
Yes, for Mr. Anderson.
Thank you.
Let's see. Okay.
He's not in your office, okay, I'll get you. Change it there, dude. He's got only a couple cameras.
You have the floor, Mr. Reich.
All right, thank you. Mr. Anderson, did someone under your supervision and control produce the swept analysis that was just up on the screen?
Yes, that's correct. Yes, that's correct.
And who under your control produced it?
This was produced by an engineer. His name is Reese Smith.
Reese Smith?
Correct.
Okay. Any other engineers or any other people help with that?
It was also reviewed by a senior engineer. Her name is Anna Beheshti.
I think you'll need to spell that for both me and Mr. Block.
Behshti.
Okay. Anyone else?
No.
So what is the date of that analysis? Perhaps it was on the screen and I missed it, but what's the date of that swept analysis?
February 26th, 2026.
Okay. And do you have an explanation for why that document wasn't produced until, I believe, Monday of this week? Produced, I mean, filed in the record.
It was produced on the date of the document. It was provided in response to a record request.
Well, when was it filed? When was it filed in the docket?
Do we know when it was filed? Just a moment. Do we know when it was filed? On March 11th, it was filed.
And do you know why it was filed? Why it wasn't filed earlier than March 11th?
We received the request on March 4th. There were questions prior to that record request during these hearings pertaining to swept path analyses, and we anticipated that that request may be made and prepared that assessment on February 26th in anticipation of that record request. When that record request was made, we then responded to it, providing the swept path analysis.
On what do you recall what date you testified on? The first date you testified in this hearing?
March 4th.
Right. So why did you or the company not produce the swept analysis prior to your getting on the stand on March 4th?
There was a previous swept path analysis included in the reports that were provided. I believe included in the stormwater management report and with the site plans, with the site plans. And that swept path analysis, we thought may have been sufficient to answer the questions that we were anticipating at the time.
Well, I'm a little confused because when I asked you about the swept path analysis, you were obviously looking at something and talking about it. But when I asked to have it put on the screen, I believe your counsel, the company counsel said, oh, we haven't filed it yet. So it's, you know, it's not ready to be put up on the screen.
There are two swept path analyses. One is included with the site plans. Just a moment. That's not this one. Yes. Just a moment, please. So the civil site plan that's included with our supplemental filing exhibit MSA indicates a layout that's based on a previous swept path analysis that started with a vehicle already on the parcel's driveway. It did not start on Colebrook. That swept analysis was used for verifying vehicle extents within the parcel, but not on Colebrook. So when questions arose regarding the ability of a vehicle to enter from Colebrook onto the site, that previous analysis was not sufficient for addressing that question. The swept path analysis dated February 26 was prepared specifically to answer that question about a vehicle's ability to enter the site from Colebrook.
All right, well, I'm frankly still puzzled why a document that was prepared on 2/26 and that clearly in your testimony showed entry from Colebrook Road, therefore going, you know, right past my client's property, was, even though it was prepared on 2/26, why wasn't it turned over or made part of the record prior to your testimony so that I would have had, and everybody else would have had, an opportunity to cross-examine you on that document?
You have the opportunity now.
That is not, well, I'm not responding. I'll let Mr. Kelleher take that up. I'm asking the question of why wasn't it produced earlier? As every other party has produced relevant documents in this matter, either in response to requests or otherwise. This document should have been produced prior to your testifying.
Mr. Reich,
Yes.
could you reference the underlying obligation that to have produced this document? Like, are you maintaining that it was responsive to a record request?
Well, I can't put the record request together because I didn't, we did make a record request regarding these kind of, well, let's see, yeah, so your record request dated February 20, yeah, EFB, I'm sorry, Mr. Pucci's request, Oak 157.
I'm sorry, is that 157?
157, yes.
Okay, 157, good.
157. I can't determine because it says date filed and I can't determine if that's the response date or the request date, but anyway, the date filed, it says, is February 20th, 2026, in response to provide a swept path analysis for the largest delivery vehicle, demonstrating that all turns into and out of the site can be completed without encroachment on a 360 Colebrook Road or any other private property. Include vehicle turning templates drawn to scale for the largest expected delivery vehicle at the actual driveway location, and it goes on. Response, a swept path analysis, see attachment ZYC, and I've never seen that attachment, has been performed for existing and proposed access drives within the site's property boundaries to confirm adequate access for fire trucks and emergency vehicles, as well as delivery trucks to deliver best units. Now, that wasn't an adequate response because I was asking about not internal, the town was asking for not just internal swept analysis, but all swept path analysis. And that wasn't answered until we asked for it during the hearing on March 4th when you were testifying. So I still don't understand your question, Mr. Keller. That's what I have.
Well, no, I appreciate that. That provides the context. Thank you.
It should have been provided in any case as a supplement to anything else they had provided, regarding swept path analysis on the property, and it was not.
I appreciate your question, Mr. Reich. So the OAK 157 question, I at the time believed that we were responsive to the question. I do see and hearing your clarification of what that original request was, and understand that you were looking for something a little different than what we provided in that response. And in that regard, we then prepared additional information to supplement that response to OAK 157 in the following response with the updated swept path to show what was going on Colebrook. We were initially reading your that request for OAK 157 to be about the design of the proposed site, which is really interior to the site. I do understand that the request was also looking outside the site, and that's the supplemental information we then provided.
Well, are you finished?
Yes.
Could you read back the first sentence of OAK 157, which is not actually my request, it was a request from Mr. Pucci, although I had a similar request in my IRs. Just read the first sentence under OAK 157.
Provide a swept path analysis for the largest delivery vehicle, demonstrating that all turns into and out of the site can be completed without encroachment onto 360 Colebrook Road or any other private property.
Okay. Reading that now, is there any question? I mean, do you have any question that IR was not perfectly clear, that we're looking for a swept path analysis that would include a turn from Colebrook Road or any other private property into and out of the site, not just within the site?
I do understand that now with the benefit of the context of these conversations. Yes.
Okay. So you did produce it on or about on or about 2 days ago, I believe.
March 11th.
March 11th. Okay. Okay. So you don't really have a valid excuse for not producing it until after you testify, correct?
I believe I explained my interpretation of the original request. We were looking at, as was brought up on the screen when we were looking at that review, there was a portion of this, there are several portions of the existing driveway that abut 360 Colebrook interior to the site. And the previous swept path analysis showed that there were no encroachments on 360 from areas interior to the site. I do understand with the context of these conversations, and since we provided our response to OAK 157, that more assessment of the condition on Colebrook Road and at the initial area was the intent of that response, and that is why we then provided supplemental information.
Are you finished?
Yes.
Once you received the Oak 157 question and interpreted the way you did you check with anyone at the company to determine if your interpretation was correct?
Yes. Mr. Anderson and I spoke, and we were of agreement that we thought that your request was adequately answered in Oak 157.
Okay. So Mr. Bonito, for the company, you determined along with Mr. Anderson that what I would call is the incomplete response was complete as of the date you filed it with filed it in the record, correct?
Yes, sir. That's what we're saying.
Okay. Was any swept analysis for the entrance from Colebrook Road onto the property, onto the entranceway to your site? Was any such analysis done by your predecessor, whose name I don't quickly recall, but your predecessor in your company?
Is that question posed to me?
Yes, Mr. Anderson. Sorry, it was Mr. Guralchuk, Guralchuk. Did he perform any swept path analysis for the same swept path analysis that that you've now filed as of March 11th?
No, and I'll also note I have been the civil engineer of record for the design of this site for the entire time this project has been commissioned to my company. There have been several people on my team. So go ahead, Mr. Brock.
No, go ahead. Go ahead.
There have been several people on my team during the time, on my company's team, but I have been the civil engineer of record for the entire duration. And for the entire duration, there have been no swept path analyses prior to that date for vehicle turns from Colebrook onto the driveway.
So
just one second. I have a small issue I have to address. Just a second, please.
Sure. Yeah.
Okay, thank you very much.
Mr. Anderson, do you know why Mr. and I'm going to get the pronunciation wrong, Mr. Guralchuk, is that right? Do you know why he, although he was listed in the original witness list for the project, why he didn't end up testifying in this hearing?
Mr. Guralchuk was not involved with the civil engineering design explicitly. He was involved in a more managerial role.
All right. Well, I'm just confused because he was listed as the company witness in the original listing of witnesses and in the original petition, and you've testified that you've been through the company, you through your own company, which Mr. Guralchuk is or was a member of. You've been involved from the very start of the project, so I'm just confused as to why Mr. Guralchuk was listed and then not listed and then delisted.
Mr. Reich, we had determined along the way that Mr. Anderson would be more able to answer these questions, given the nature of the fact that they're civil primarily, and the previous witness that was identified was more of a project manager. So we felt it was important to bring someone that has the most familiarity with the civil and design of the project to be supplemented to talk to these to answer these questions.
All right. Mr. Anderson, was your projected testimony in this proceeding ever amended to add a description that you would be doing a swept test on the property?
I'm sorry, I didn't really understand the question. Do you mind clarifying that?
Yeah, you provided pre-hearing testimony. Well, let's see. I think we went through this the last time. You didn't. I think maybe you adopted Mr. Goralchuk's pre-hearing. I'm not sure I've seen a pre-filed testimony from you. Does that exist?
We filed the testimony, right? I think we filed the testimony. Yeah. We filed the testimony. I don't think so.
And I apologize if in looking through all the documents, I missed that, but I don't seem to have it anywhere in my files.
I'm not sure, Mr. Raish. I have to look.
All right, well, we can keep going.
Yep.
Mr. Goralchuk, how many, I'm sorry, Mr. Anders, how many swept diagrams have you produced or had produced under your supervision in your, not here, but in your career?
I don't know an exact number. It's probably more than 50.
Okay. Have you ever done a swept analysis on a project like this one involving a WB67 truck?
Yes.
And how many?
I don't know again off the top of my head, but I would say in the dozens. It's a very common vehicle for a large vehicle to be used in a swept path analysis.
Okay. And did you use it in this case because it was either Tesla told you, or you know from your own experience that that's the only kind of a truck that could take the current model of the Tesla BESS BESS battery packs that are intended to be installed in this project?
I referred to the experience of multiple engineers within my firm who have designed and overseen multiple similar BESS sites. And this was the vehicle that in our professional experience represented what was commonly used for a delivery vehicle for BESS sites.
Are you aware of a vehicle larger than the WB67?
Yes.
And what would that be?
There are many construction vehicles larger than a WB67. I don't know exactly. I'm not sure my question here. When we designed it to the WB67, there are many vehicles of all shapes and sizes. You know, if you're bringing a wind turbine, for example, to a site, that's going to be a very significantly larger vehicle. It's but this
is it fair to say that the WB67 is one of the larger trucks on the road?
Yes.
Okay. Have you ever done a swept analysis in a project in which the swept analysis predicted a certain turning radius, and when in actuality the truck, let's say a WB67 truck, took a load up the same road or the same pathway that you analyzed and tried to do the turn, that the turn was actually a little bit larger or any bit larger than what was predicted through your model?
Yes, the part of a vehicle's ability to make turns includes the skill of the driver of the vehicle. We do generally include some factors of safety in our analysis to allow for a little bit of extra space for vehicles to maneuver.
I'm not sure you fully answered the question. The question is, have you ever, in reality, have you seen a situation where a swept analysis that you performed showing a certain radius ended up in reality when that same truck tried to make a turn that they could not make the turn that your model predicted?
I've never seen that issue with the WB67 under my analysis. In all of the designs I've done, I've never had a complaint from a property owner that a WB67 was not able to make a maneuver that we had identified it could make. There are some instances, for example, I'd say notably with buses, which are a smaller vehicle but have different challenges and many different skill sets of bus drivers, where I have, in my experience, identified a swept path analysis. And then we did look at modifying that to provide extra space for the comfort of those bus drivers. But that is a different situation. And again, for the WB67, I've not had any, never in my experience has an analysis we've done for WB67 had a situation where a driver of those vehicles was unable to maneuver what we had identified on our plans.
Would you agree that there is a risk, that there is at least a risk in this case or in any case where you're involved with a truck taking a load like a, as heavy and as large as a BESS package, basically BESS battery package? Would you agree that it's possible that a truck trying to make that turn might not be able to make the same turn that you had modeled?
No, I don't have a concern of that risk, no.
Is there any such risk?
I don't believe there's a substantial risk.
No, that wasn't the question. I was asking any risk.
I haven't seen it. In my estimation, a competent truck driver of a vehicle of this size would be able to make that maneuver.
Have you heard, forget about your immediate experience, have you heard of anybody, any other situation where a truck of that size or any large truck was not able to make the turn that it was modeled to be able to make?
No.
Okay, so your statement is there's no risk of that analysis being flawed in reality?
In engineering, we don't work with extremes of that nature. I can't say I'm able to predict every possible scenario with various truck drivers. So I'm not willing to say that there is no risk, and I would not say that to anything, and I think that would be industry standard for my profession. I can say that there's no substantial risk, and with an industry standard, we've performed an industry standard assessment, and I've never heard of a truck driver for a WB67 not being able to make a maneuver that we've included on any of the projects that I've been a part of.
All right. So I've seen the sketches. I've seen the swept drawings. I haven't seen a report that described the vicinity of the site where the simulation was modeling. Is there such a report that's attached? It's not attached, but is there a report separate from the sketches that you put up, the swept analysis sketches that you put up?
There is no report, and there's no requirement for a report. In my professional judgment, it's common industry practice to provide diagrams as we provide to demonstrate the implications of swept path analysis. The analysis then is used to prepare site plans, as we have done, or to verify site plans, particularly relating to the extensive pavement and other access means for vehicles.
Is it best practice in your industry when you are doing such a swept analysis to have your engineers actually go out to the site that the swept analysis is modeling?
We do generally go out to site, and my engineers did go to site.
All right. We talked about this at the last hearing. You told me that you had to check certain things with your engineers. Have you spoken to your engineers since your last testimony?
Yes.
Okay. What did you discuss?
Two of my engineers went to site on April 11th, 2025 for a site visit to observe the physical conditions of the site. They parked at the entrance to the site and walked the full extent of the driveway, as well as other portions of the site.
When you say the full extent of the driveway, do you mean the driveway going all the way up to the proposed site of the BESS?
The driveway does not currently extend to the proposed site of the BESS. The driveway extends partway into the site, and they walked the extents of the existing driveway and then continued on foot through the remaining portion of the site to the location of the proposed BESS.
Okay. So even though you say there's no completed road or no completed driveway all the way up to the prospective site of the BESS, they on foot traverse that entire path?
Correct.
Okay. Did they have any comments about the condition of the path, the condition of the road, the condition of Colebrook Road, anything that they observed on their site visit?
A site visit report was prepared documenting their observations.
And where is that site report?
We have that site visit report.
That site visit report was provided to the company?
Yes. So will the company please produce it?
I'm sorry, did you say, did we produce it?
I said, would the company please produce the site report that you have in your possession?
The company would be willing to produce that site request if it was a record request, yes?
We'll make it, I'll give you a record request number. This will be RR-INT-3.
And when can you make that site report available?
They could, take a couple moments to get it together. Friday.
Couple of moments?
Tomorrow, we can get it tomorrow to you, sir.
Okay. And will Mr. Anderson be available to testify again on Friday?
Yes.
Would he be required to testify on the results of a site visit? Is that the question?
I'm going to get the site visit report. I probably will have questions about it. So yes, I'd like to be able to question him about it. I don't think I've gotten a response.
We're just waiting for a record request number.
Oh, I thought it was record request INT-3.
Oh, okay. Sorry about that.
I don't think there was a question pending, Mr. Reich.
The question was whether Mr. Anderson will be available to testify
yes.
about that report.
Yes.
Yes.
Okay. All right. Thank you. Now, the notes that you had in front of you, are those notes encompassed in that site report?
Notes that I have in front of me include the swept path analysis that we've already included as a record request.
Let me be more specific. You had a little notepad that you were looking at when you were talking about. That's the one.
No, this notepad includes the date of the site visit, which I noted as April 11th. There's
Right.
nothing else in here pertaining to the site visit. I've written down some of the names of the people in the room with me and a couple technical terms to help with my memory.
Okay. Is there anything else about the swept analysis or the condition of the site or the condition of the road or anything in that notebook?
No, sir.
So you've testified, your testimony today has included everything relevant to your work.
Yes, sir.
Regarding the site. Okay, thank you. So let's go back to, this might be a question for Mr. Benito. Can we put up the, I guess it was one of the swept analyses that showed the so-called encroachment onto my client's property. Can we put that up again?
Yes, I can put it up.
Thank you.
EFSB.
Okay, are you able to make that a little larger? Please? Oh, wait a minute, I can do it. I guess I can do it. Yeah, I have it. Okay, sorry. So show me, just describe to me off this map, what is the road? Show me where the road, the entranceway road is, and then there's lines that are going off this entranceway road, and then there's a black line on both sides. So just tell me what all those different lines are, Mr. Anderson, or Mr. Benito, whoever.
The solid black lines represent the surveyed property lines. The other various lines on the figure here show the existing paved driveway. And the other lines here show the swept path analysis remaining within that existing paved driveway and within the property line.
All right, so Mr. Anderson, perhaps you can show me, because I'm looking at this drawing. You can show me the swept path analysis portion of it.
Yeah, could we zoom out to include the callouts?
Sorry? Oh.
Yeah, if we could zoom in on those callouts and where those arrows point to. Thank you very much.
All right, so for the, okay. So for the record, this is, which document is this again, just for the record?
It is RR. What is it, Mr.?
It's on the up. It's shown on the upper left. So RR-EFSB-4 parentheses 1 close parentheses.
Okay, but this is, but as I understand it, 4 parentheses 1 included 4 separate drawings, right?
This is the first of the 4, but I can move to any other ones as you wish.
Well, for the record, I just want to make sure that the record will show which of these 4 drawings we're looking at.
This is showing the first one.
Okay, and what's the title of it?
Sweep path analysis HP 100 aerial fire truck approach from north.
Okay, all right. Let's shrink it down again and go to the beginning. Okay, so Mr. Anderson, so this is not an analysis of the turning radius of a HB 67 truck. It's a turning radius of a fire truck. Am I correct?
This particular image, that's correct. The third image represents the WB67.
Right. Does the third image also show the encroachment that was testified about?
Yes.
All right, then let's go to the third image, please. Sorry.
This is the third image.
Okay. Yes, I see. So, Mr. Anderson, just describe to me off this third image, which is the swept path analysis for a WB 67 interstate trailer. Show me where the swept analysis diagram for a better term, for lack of a better term, is shown on this drawing.
When you refer to the diagram, the truck itself is shown at the left side of the screen at its starting location.
Hold on, I don't, left side of the screen. I'm looking at the left side of this. I don't think, see, oh, is that the thing, the thing at the very left top that's got four wheels and at this point, an indistinct, that's the WB 67? Yeah, let me
That's, yes, that's correct. That shows the dimensional proportions of the WB 67 at the start of the swept path analysis.
Okay. And so the road that is coming down, presumably from the north, right, is Coldbrook Road?
Correct.
And the turn that it's making onto the driveway, the entranceway off of Coldbrook Road, is that shown by the lines that cross the left-hand, I guess the western side of the driveway, the left side, is shown on this map?
Yes, the lines that extend from that vehicle I just described, which continue along the extent of the driveway, that represents the full extent of the wheelbase and vehicle overhang clearance as that vehicle navigates its way into the site.
All right, so so the pathway that's with kind of very narrow lines and then it seems like they go to no width and then it comes back to an actual width as it gets onto the pathway. Is that what you're referring to? There's some very faint lines. Yeah, in the middle of the roadway as you come down the roadway from Coldbrook, but right, it seems like right in the apron or whatever you want to call it of the entranceway, there's the lines almost touch, they merge. I'm a little confused as why, you're showing a constant width of the pathway and then it seems to go to zero.
If we can zoom in over at the intersection of Coldbrook and the driveway. So what happens here, so you see in Coldbrook, the outermost lines which run up and down on the plan here represent the existing pavement extents, both at the far left and far right sides on either side of the vehicle that I just indicated.
Oh, I see. So actually the lines of the vehicle are the two double lines on either side of, I'm sorry. One is in the lower left, the other is above it on the drawing. And so those are actually the lines of the wheels of the truck as it's going into the driveway, right?
I'll answer your question in a clarification. You see where the leader L3 is pointing, that note?
Yeah, L3 is pointed to a dark line, which is the left-hand part of the rectangular piece that is part of the entrance to the driveway.
That's correct. And that leader arrow crosses two lines that kind of come out. They appear to manifest out of the vehicle and then sweep their way into the site.
Yes.
See those two lines? And they're very close together. The innermost line represents the wheelbase. So that's where the vehicle's wheels will actually, the full extent of where the vehicle's wheels will come in as it sweeps through and makes that turn. The outer line is the overhang of the vehicle, because the bumpers of that vehicle will extend a little past the wheelbase. And that's what that second line indicates there. And you can see at this location, so that's the kind of right side of the truck. There's a similar condition on the left side. On the left side, those two lines are basically on top of each other, just based on the way vehicles move. And from there, you can see the full extent of both where the wheels will be and where any portion of the vehicle will overhang as it makes its way and makes that turn. And you can see that's why that area widens out at the entrance and then narrows up once that vehicle becomes straight, because as the vehicle turns, it takes up a larger space as it makes that turn. And then those two lines come closer together once the vehicle is straightened out on the driveway.
I see. Okay, so it's the two lines that are on the two lines on the bottom where the where you have the little cursor or blow up sign. Right there. So those are the wheel lines. That's a depiction of the line, the wheels of the truck.
The wheel and the overhang clearance for the vehicle. Yes.
Well, okay. My understanding was that the first set of double lines is the showing the wheelbase as a truck is making the turn, and the other set of double lines was the you call it the overhang.
Just so we can make sure we're both talking about the same thing, could we zoom in very close on where the cursor is currently pointing? Thank you. And can we put the cursor over one of those lines, please? Thank you. So that line, so that line there indicates where the wheelbase is located. That's the furthest extent the right wheels on the vehicle will reach. We can now move the cursor to the parallel line that's outside of that one. Thank you. That line represents the overhang envelope of the vehicle. That's where its bumpers and any other appurtenances on the vehicle above the ground may reach. So that's not running over the pavement, but that's where the bumper up, a bit above the pavement would extend to.
Okay. So the double lines represent the top part of the double line represents the wheel, the right-hand wheels, the right side wheels of the truck, and the left part of that line represents the overhang. Is that what you're saying?
Correct.
Okay. And where does this map show the left wheel, left wheels?
Yes.
For whatever?
Yes, if we move the cursor over to the right and stop right about there, that line is the same on the left side. Now, at this particular location, the wheelbase and the overhang are effectively on top of each other.
Okay. All right. I understand. So you got two lines on the bottom, one line on the top. That's just because of the way the vehicle operates when it's in a turning motion, making a left-hand turn, right?
That's correct.
Okay. So the overhang, is there more than one overhang on a truck like this? I mean, is it just the bumpers, or what else hangs out from the truck when it's turning?
It's primarily the bumpers. Sometimes the body of the vehicle can extend a little bit, maybe a couple inches past the wheels in some cases. But generally, it's usually the bumpers.
And
let me interrupt just because it is 6 o'clock. We would be willing to go longer a little bit if that would be enough to accommodate you, Mr. Reich, if other people are available to go, say, another 15 minutes. So let me start with you, Mr. Reich. can you finish this questioning in 15 minutes?
I hope to, but if I don't, then I think Mr. Mr. Kaplan has already said that he'll bring Mr.
He's
Anderson
coming back anyway on
There's
Friday.
no reason to stay longer. I can stop now if that's better for everybody.
Are we muted? Well, I'm thinking it probably makes sense to end tonight. Now, and I do want to speak about Friday. We're not going to start on Friday until 10:30, just because of a conflict with the stenographer.
Okay.
And we are going to have a different stenographer on Friday. So Mr. Brock will look different on Friday. Is there anything else we need to add?
When you're back off mute, I had just a question for you, Mr. Keller.
I was wondering if we could start even later, but unless you're trying to jam the whole thing in so we can finish Friday, absolutely. Because then I can do the event that I wanted to do, but figured I'd make another plea.
What time does your event go to?
Yeah, even if I could make a appearance and leave early. Yeah, it starts at 9:30. They're usually 2 hour. But even so even if we started at like 11:30, that allows me to go and I can leave early and come to my office for your proceeding. So I guess I'm proposing, can we start at 11:30 instead of 10:30?
So we obviously have no problem with that. I would just,
Mr. Kaplan, go ahead.
Yeah, I just wanted to say that Sean Morris is only available tomorrow, and then he's out until the middle of April.
Good.
You mean only available Friday,
I'm
right?
sorry, I'm sorry, only available Friday. My mistake. So I just want to make sure we are able to get to him and have all of his questions asked and answered.
I take it back then. I guess I take back my request. If you want to start at 10:30, we can do that. I don't anticipate questioning him all day, but I just don't want to chance it.
Okay. Are people able to give estimates of how long they expect their questioning to last? If I could start, and so the main topic on Friday is safety. I would ask both about your estimates on how long your safety questions will take and also how long your other questions will take. Mr. Pucci.
Right. I don't anticipate that I would be longer than I was today. I was finished by lunch today.
Okay, Mr. Reich.
So for Mr. Anderson, probably half an hour. For the safety person, that was a subject of another request, and that is Mr. Benito said several times today that he needed Mr. Morris, to testify to certain items. And so I have some questions. I have a request for documents related to Mr. Morris for Friday. And I can tell you what they are, or like,
I'm sorry, you're saying that you have requests for documents
for
Mr. Morris?
I'll be brief. Mr. Benito's talked about several things in his testimony, and he said that Mr. Morris would really have the answers to these questions. So since Mr. Benito didn't produce any documents related to these questions, I'm asking the company if they will produce some documents that would be useful to my examination of Mr. Morris.
Are you talking about record requests that you have already issued?
I don't think so, but I do know that Mr. Benito testified to certain things today that they haven't produced and that are certainly relevant. And so I think they should produce them in the spirit of producing any information that's relevant to this, directly relevant to the proceeding. It'd be easier if I just told you what they are. Okay.
Yes, please do that.
He testified, he said that he didn't have a final contract with Tesla. This is Mr. Benito, but he kept referring to the Tesla contract will have this provision and that provision. And I can't give you the exact thing without going back and looking at the testimony. But he kept referring to a Tesla contract. So to the extent that there is a Tesla.
No. I don't I want to make sure I'm understanding you. Didn't he refer to terms that would go into a contract that hasn't yet been created?
Well, I guess Mr. Benito will have to answer that.
Yes.
Okay, I had the impression because you kept referring to a contract that you were referring to something that you had seen from Tesla or reviewed, a sample or maybe even another project in that, but that this is something that Mr. Morris would testify to.
No, that's not what I meant. I think we were talking about mock contracts, and I feel like I was very clear that we don't have a contract nor a mock contract. And my testimony was based off of an IR or a record request where I was reading specifically what Tesla told me or told us with regard to the 40% fan speed.
Could I ask another question with Mr. Reich here also, since we're doing this together? Have you signed any other contracts with Tesla for the projects that were mentioned already in the transcript, either in Texas or New York, or the one that was not initially revealed, but we discussed earlier about the Tingsboro project?
No, sir.
So you have no other contracts with Tesla?
No, sir.
Okay. And you don't have a sample. You also don't have a sample contract from them.
No, sir.
Okay.
Hold on, Steve. Let me just follow up on that.
Sorry, I'm just going to interrupt. I just want to confirm that Mr. Brock has additional time.
Yes.
Right now. Okay, thank you. Continue, Mr. Reich.
Yeah, Mr. Benito testified that I think maybe in the first day of his testimony that not Moraga, but an affiliate of the affiliate of the Rhineland company was developing a project at Tingsboro, and that project he testified today was actually operating. And so I assume that there's a contract between Rhineland or one of its affiliates and Tesla at the Tingsboro site. And if so, I would like to see that.
The Tingsboro.
Yes.
Tingsboro is not developed yet. It's in negotiations. It was part of the 83E procurement process. And
there was testimony today that Tingsboro was actually producing electricity.
No, there wasn't.
Really? I heard because under Mr. Ferry's examination, there's all this talk about, well, it's not really, it's not producing electricity to the grid, but it is producing electricity. Did I get that?
I think that was I think Mr. Pucci was asking about Medway.
That may have been Midway. Yeah.
Which is a different company.
Okay. So you have no contract with Tesla at the Tingsboro site? Not you, but Rhineland has no contract with Tesla at this time process?
No, sir.
Okay. You also, Mr. Benito, you also testified about a global failure report of Tesla. You referred to a global failure report of Tesla. Is that a document that's in the record?
I was referring to the document you had up on the screen where I said Mr. Morris would be most appropriate to discuss that. And that particular document that you had up on the screen represented the global failure rate for the Tesla Megapack 2s.
So that was the chart that had six different.
That's correct.
Six
Wait,
different
I'm sorry. That has 6 different what?
6 different worldwide incidents for Tesla?
Yes, sir.
Okay, that's what you meant by global failure report?
Yes, sir.
Is there any other global failure report besides what you're just now referring to?
No, sir.
Okay. All right, Steve, do you have any other questions? Because
No, I think that's no, I don't.
Okay.
And did you give an estimate on the length of time, Mr. Reich, that you expect your safety questions to take?
Well, I think with Mr. Anderson, it should be half hour to 45 minutes.
And how about for Chief Morris on safety?
Chief Morris, it depends on Mr. Pucci's questions. If he may well cover everything I have. If not, I'll probably have a half hour with him.
And Mr. Kaplan, how long do you anticipate on redirect?
So far, we don't have any redirect.
Understood. And I realize that could change.
Yep.
All right. Thank you. So
we could start at 11:30.
Are people prepared to go? Oh, wait. No, we're not prepared to go late on Friday. Is that right? 5 o'clock cutoff? Okay. It is a Friday.
How about you start at 11:30 and you give me a cutoff if I'm like.
You know, I think
Mr. Reich, then go.
Are you, Mr. Pucci? Are you okay with Mr. Reich going before you?
No.
Okay.
All right, we'll start at 10:30.
We could give you a cutoff. I mean, I'm. What's a reasonable cutoff for Mr. Pucci in the afternoon?
2-hour cutoff.
Sorry, it's very doable for us to finish on Friday. So that's what we're negotiating here, Mr. Pucci. And if we are able to get adequate assurances that we will finish on Friday, I'm very supportive of your going to the mock trial.
I appreciate that.
And I think that would take the form of limiting initially how long your cross examination is.
I think in seriousness, the best I can commit to is 2-hour max.
Oh, well, that's adequate, right?
Yeah.
Yeah. I mean, if you're willing to commit to that, if need be.
Right. My attention span doesn't go much beyond that, as you know. So.
I think that's going to be adequate, right?
Doesn't have too many questions. I mean, right now we don't anticipate too many questions. So
okay. So 11:30 start time. Is that what you requested, Mr. Pucci?
That would be tremendous. Yes, I appreciate that.
Okay. So we'll do an 11:30 start time. I'm just trying to think whether people should. What do we do about lunch?
Before?
I mean, I don't want to break for lunch at 12.
Before? Oh, yeah.
I think people.
I mean, at 1
Brunch.
o'clock. Usually, there's court is 1 to 2 lunchtime. Maybe we could have a shorter lunch. I could do my best if I start at 11:30 to be finished by lunchtime. Like, in other words, even if I go over past 1 a little bit. then we would be done. We could have a lunch break and finish
Okay.
the rest.
So let's do that. All right. We are going to finish Mr. Pucci's testimony before lunchtime. And people are advised to, eat a late breakfast or whatever, just to accommodate a late lunch. I think that's going to be appropriate. All right. Are there any other matters that need to be addressed before we adjourn for the day? Hearing.
Oh, can I actually just
No.
confirm that?
Yes, sir.
I just want to confirm Mr. Callahan is done.
He is done with the board's questions, and I believe everyone else, but can you confirm that, Mr. Pucci?
Yes, I can. Thank you very
And
much.
Mr. Reich and Mr. Ferry?
Yes, I'm done.
Okay, thank you.
Yeah, I'm done.
And if the self-pays are there, if you could confirm that as well. All right. Mr. Kaplan, Mr. Callahan can be excused. Thank you.
Thank you.
Okay, great. We will see you all on Friday morning at 11:30 a.m. Thank you very much.
Thanks very much.
Off the record. Bye-bye.